Yeah, so
Judgment 1501.
We are of the view that further directions are required to be issued to ensure effective compliance with the order dated 27/4/22 as well as the order dated 28/2024 passed by this court. Accordingly, and without prejudice to further consideration of the contempt proceedings, all the home buyers represented by the present petitioner shall furnish or hand over their respective letters of authority in favor of the reached contender number 1 on or before 10/7/26 for the purpose of enabling them to avail financial assistance towards completion of the project. We expect due and complete compliance with the present directions within the aforesaid period. lists the matter on 15/7/26 for reporting compliance with the aforesaid directions. We'll take a call after the submission of the authority.
Miller.
Eight zero one Nancy.
Please, Your Lordship. Your Lordship, there's a discharge order that is being challenged in the Supreme Court. The High Court had
Okay, Counsel?
801, Your Lordships. It's coming up on 26th of May, Your Lordships.
Yes.
Please, Your Lordships. Your Lordships, it's coming up on 26th of May. This is a matter where the petitioners were first discharged by the trial.
You are respondent.
Please, Your Lordships. Your Lordship.
What is the urgency in it?
Your Lordship.
Before vacation.
Please.
Take post it on 12th August.
Please, Your Lordships, any date before that, Your Lordships. Your Lordship, the only
There is no urgency.
Your Lordship,
Will not give any date if you insist.
no, apologies.
Yes.
802.
802.
Lord, 802, I am appearing.
Bail application rejected. Yes, not to be deleted. Not to be deleted.
My lords, it was showing in today's list, but it did not come, my lords. May give any date in the coming week, lordship.
802 tentative date is 29th May.
My lords, it may very well, my lords, very well, my lords.
Yes.
Obliged, lord.
Next.
803.
Same.
My lord, 803 also 29th May
not
it is
to-
not to be
deleted.
deleted. I'm obliged.
804.
This
25th May.
not to be deleted, my lords. This is a labor matter.
What is the urgency?
Lords, I am out of service since 1983, my lords. And this matter has already been dismissed in non-prosecution, my lords, once. And the matter was then revived and then
30th July. 30th July.
like,
Next.
805.
My lords, I'm appearing for the petitioner and I filed for stay of proceeding before the learned trial court because before the learned trial court, my lords, the matter is listed for pronouncement of award in the MSCT matter on 26th May.
No, who are you?
I'm for the petitioner, my lords.
No, not petitioner. What is your status? Claimant, owner, driver,
My lords,
insurance
I'm the
company?
registered owner of the vehicle, my lords.
Hmm.
But my lords, the vehicle was sold.
So it is the MSCT proceedings are not yet final.
No, my lords.
Why are you here?
My lords, on 26th May, the matter
The SLP, against which order this SLP is filed?
order, my lords, the SLP is against an order where the our application for order 1 rule 10 was dismissed.
110 dismiss. Yes, no urgency.
My lords, the
No
my lords, the
urgency.
vehicle is sold as
No
per-
urgency. Not to be
as
deleted.
per section.
Tentative date is showing not to be deleted.
Item 1.
This is a second bail application, my lord.
Yes.
On 20th of March 2024, that my bail application was dismissed after granting of leave, my lord. After 2 years, my lord, the matter could not be progressed for final hearing, even though the order was passed, appeal to be expedited. He is a lady of 55 years old, my lord. This is a case of circumstantial evidence. She has already undergone 8 years, my lord. You may consider for bail at this stage.
Bail will not consider it. Once it is rejected.
24 it was rejected, my lord.
Yes.
The
24 or 25. Rejected on merits means rejected.
26, 2 years, the matter could not be progressed.
Post the appeal for final hearing in the month of November.
Your Lordship, I would also like to bring to your Lordship's notice that the custody certificate
That is wrong. That is wrong.
should be
Yes.
Only I.
Appeal. No orders are passed in Mali.
Item 2.
May it please your lordship. This comes to your lordships after notice. Your lordship had issued notice.
Your Lordship, I'm seeking a passover. Mr. Rajdhani is on his legs in court number 3.
Passo.
Obliged.
3.
Item 3, sincere apologies. We are not being filed counter affidavit. I'm seeking
2 weeks per counsel.
right.
4.
Please, your lordship.
Yes.
3 is unserved. The notice is in transit. Lordship, may I-
Issue press notice to respond number 3. Returnable on July में कभी कर देना 24th July.
My lords, I beg to appear for the state in this matter, my lords, item 4. My lords, the
Yes.
accused is not appearing before the trial court. My lords, after your lordship's interim protection, also she has completely stopped appearing in the trial court. Let her, my lords, appear in the trial court at least.
Who? The petitioner?
The petitioner, my lords.
Meanwhile, petitioner shall appear before the trial court as and when the
Matter is listed.
matter is posted before the trial court. Yes. Next.
Great. Great.
Well, item 5 is this contractual pharmacist matters. Lordships have issued notice in similar matters, my lord.
That mobile unit.
Yes, ma'am. It's
Issue
state of
notice.
this,
Tag with SLP.
This is diary number 61050. Diary number 61050 of 25.
61050.
Shabindra
Kumar.
Yes, sir.
SLP civil diary number 61050 of 25.
Well, there's just one request. There's a change in the EOR because the EOR got filed and there's a revision of the Wakalat number. My revised appearance may be filed. May be taken on.
Physical absence.
So great.
Yes.
Takes.
No, sir.
Yes.
This appeal filed by the state was dismissed on the ground of delay. This is the matter which needs to be heard on merits.
Yes.
Contractual-
135 days delay, it is dismissed.
135 days.
If you agree, we'll send it back. Let it be decided on merits.
And meanwhile, no, the contempt has been filed, my lords. So no, that also needs to be stayed. Mandamus has been issued, my lords.
Just give me 10 seconds. Have you got Wakalatnama for everybody?
Otherwise, we'll stay the order.
I'll
And it
do
will
one.
remain pending here.
Exactly. Because when it falls from your lordships, lordship will just have it on Tuesday. I'll try to get Wakalat for everybody. That's the only way I can make a statement, Milos. I can't make. I prima facie agree, Milos. As an officer of the court, I have no difficulty. But my learned friend will need to get Wakalat. I'll get it by Tuesday.
Third learned counsel for the parties. Post up. Mr. Gaurav Agarwal, learned senior counsel, appearing for respondent. Respondent number 1. Place for time to seek instructions.
Lordship, I have it on Tuesday.
Post on Tuesday.
Great.
Obliged. Contempt has to be stayed.
But there is
Much.
summer vacation. Court is in vacation.
No, much.
Who will punish you during summer vacation?
Obliged.
Yes.
7 letters.
No lawyer would be safe if this kind of complaint is entertained. No lawyer would be safe.
No, sir. The thing is this. I am on the legal point. I am arguing
It
this
is all
argument.
his personal elections. Whatever
Sir,
he has done, he might have threatened you, might have gone to police station for lodging an FIR or any action against you. It is all personal. Nothing
Sir,
related to
it is personal, but the judgment
Sorry,
says
dismiss.
denies the witness.
Dismiss. Next.
Delay.
Delay condone dismiss.
9.
Enhanced compensation.
Please, your lordships.
Yes,
In this I am for petition.
Notice.
Grateful to lordships.
Notice.
Delay is of 139 days.
Delay condone.
Grateful to lordships.
And
My lords, the High Court allows the first appeal against me, as an earlier injunction suit that I had filed was subsequently rejected for dismissed for non-prosecution.
1987 sale deed.
1980.
You want preemption to be affected and decreed in your favor after 39 years.
My lords,
Sorry, dismiss.
decree in my favor has been
Whatever, it is set aside. So rightly
it
set
remained
aside.
pending before the High Court for 20.
No preemption after 40 years. Next.
My lord, sir, kindly permit me for giving the appearance, please.
Yes, take a lesson. Again after 30 years.
My lords, in this case, my lords, the law has been settled by the Honorable High Court, treating an application under a special act, a local act. That application is treated as a suit, and the Honorable High Court has held that there cannot be an application under Section 5.
There is no application for any original application. Even if it is wrongly mentioned as suit, it remains an original application.
My lords, in that case, my lords may just see.
And civil suit is pending. The court has granted you liberty.
My lords, but my lords, the law which has been settled, the Honorable High Court has not appreciated Section 29, my lords. Section 29 says there is. It has been quoted in the Honorable High Court's order also, my lords.
There is a suit pending.
There is a suit pending, my lords. There is a suit pending, but my lords.
For the petitioner, we are not inclined to entertain the SLP. Accordingly, the SLP is dismissed. However, the pending suit, civil suit between the parties shall be decided on its own merits.
My lords, may I, one more small submission, my lords. My
Yes.
lords may keep the questions of law open, my lords, because it would have large scale if my lords, implications would be there, my
Question
lord.
of law is kept to. Yes.
Highly obliged.
12.
Yes. Well, anyone appearing? Pass over.
13.
Question here is my eligibility as a landless laborer to get assigned the plots in
You have already
Marble.
lost it.
No, my lord, the point is,
Along with the other society members.
no, kindly see page 32.
Earlier
The
process.
competent authority, district collector's order, page 32, my lord.
No, forget about it. You see, there are two lists.
Page 32.
You see, there are two lists of eligible persons. One which you have placed into service and another which the government has placed into service. And your name is not there in the government list, which is the authorized list. In your list,
Your lordship,
it is not
I agree.
signed by
I
anybody.
agree.
And in the
My lord, I
previous round
agree.
of litigation by the society,
That is correct, my lord.
Haricha
Merely because your lordship is right. Your lordship is right. But kindly see page 32. My lord, kindly see page 32. I only wanted to show that.
Yes.
Page 32. The competent authority, district collector has found my name, paragraph 4, my lord, 5 lines. Kindly see page
in the
32.
earlier round it was dismissed. Your claim was
So
dismissed.
my name was there. Kindly see paragraph 4.
You see, there is
your
no
lordship
evidence
got that?
of an inclusion of
As
your
per the
name.
government, as per the government notification, more than 16,000 applications were received. Out of these, district
It is
collector prepared a
unsigned.
list of
The relied upon list is unsigned.
my name is my name appears. Kindly see page 64. Page 70. Kindly see my name appears in the government list prepared.
Page
item, serial number 2, P.S. Danesh.
Page
70.
No.
This is the government list prepared well before 1998.
It is this list which the High Court has found that it is not a valid list because this annexure P7 which you rely is contrary to the official list. That is exhibit R21. And in that R21, your name is not there.
Correct,
Sorry.
but your lordship is right. Direct, my lord, 1 minute, one more submission.
14 letter.
14 में letter तो नहीं है यहाँ. लेटर हमारा 10 मिनट बर्बाद हो गया. लेटर लगाएं जी घर में. Yes.
15 minute. Here, the child was 4 years of age. It's again seeking enhancement of compensation. Your losses will see.
Yes.
Honorable High
Notice.
Great particulars.
16.
Ship. May it please your lordship. My lord, can you hear me, my lord? I'm always worried.
Interim order.
No, it's not, my lord. Can I please take
It
1
is an
minute?
interim order.
No, my lord, please, no. Let me explain, my lord. Give me a minute. My lord, I always have a problem with this. We see. Otherwise, will you do one thing? I see so many people in court. Please pass it over. Let me come to court.
Why don't you
I
come?
can't.
Why don't you come to court?
I'll come to court. Please pass it over.
Appearing here
Please.
physically.
I'm happy to appear, my lord. I was told I should not. Now that I see so many people, please pass it over. I'll come straight to court. Please pass it over.
Where are you
My
now?
lord, I'm within 10 minutes of court. In 15 minutes at my house, my lord. I'll come. Please, my lord.
Next.
17.
17 years.
Lordship, I am appearing for the petitioner. In this matter, we are challenging the impugned order of the Honorable High Court. Wherein the Honorable High Court
dismissed.
Yes, Your Lordship, it was dismissed. And the order, I would like to refer order dated 2/12/2025.
2020 it was dismissed. And in 2026 you filed restoration application.
Lordship, it was dismissed on 2025. I would like to refer page number 91, Lordship. That is the main order in the writ petition.
You see, 2020.
The writ was filed in 2020. Yes, Your Lordship. So the order was dismissed. The main writ petition was dismissed in December 2025. Then we filed another restoration application, which was dismissed in 2026 February. Then the second was dismissed in February 2026, and now we are before this honorable court.
Why did you file the second application? Once,
Lordship,
if one application is rejected, how the second would be maintainable?
Lordship, the first one was dismissed on the ground that the main counsel was not appearing since he was not well.
Under the
And
impute
then
order,
we
High Court has rejected petitioner's prayer for restoration of the writ petition, which was dismissed for want of prosecution on 2/12/2025. Issue notice returnable on 3rd August. Next.
18.
Much obliged.
My lordship, there was a delay of 2000 days. There was a delay of 2000 days.
Delay of 2,492 days.
Yes, my lordship. But
Short
I have
delay.
Very good merit on the case, my lord. Very good merits on the case, my lord.
Yes, yes. Whenever there is a delay, case is always good on merits.
Kindly see the school tribunal order, my lordship.
Yes.
Page number 36.
Yes.
7 of reasoning given by the school tribunal. May I read, my lordship?
What are you doing during all these days?
I was constrained by the financial and
no,
COVID
no.
also, my lordship.
No, how are you surviving 2,492 days?
My lordship.
What you were doing these days? Sorry, dismissed on the ground of delay.
8 years.
19.
May it please your lordship, my lord, short issue, my lord, of recovery rights, my lord, and squarely covered by my lord Justice Banarjee's judgment, my lord, in Abetment minerals, my lord. Same issue, my lord, expired, my lord, driving license, not renewed, and in that case, my lord, your lordship is granted recovery rights, my lord. I'm only on that issue, my lord.
When what is it expired?
My lord, driving license, my lord, of the driver.
In this case?
In this case, my lord. Identical case, my lord, your lordship has, my lord, granted recovery.
In the present case?
In the present case, my lord.
When the license expired?
20th of August 2012, my lord.
20th of August
2012.
2012. And,
yes, my lord.
And date of accident?
11th November 2012.
And when it was renewed?
Yes, my lord. On the 18th of January 2013.
18th of January 2013.
13, my lord. It's renewed.
So does it not relate back?
It doesn't, my lord.
Huh?
No, my lord, does not. Only fitness certificates relate back, not driving license.
The learned counsel for the petitioner submits that the driving license of the driver involved in the accident, of the driver of the vehicle involved in the accident.
Offending vehicle.
After the accident occurred on 11/11/2012. First of all, although the driving license was renewed on 18/1/2013, however, the same would not relate back to the date when the driving license expired, and that during the interregnum, the driver was not having a valid driving license to drive the offending vehicle. Post of learned counsel refers to the decision of this court in so and so. लिख देना इसको issue notice returnable on 31st August.
My lord. My lord, delay of 13 days.
Delay control.
But grateful to your lordship.
Yes.
20.
Lordship, I'm seeking a passover in this matter.
Passover.
21.
Yes.
Please, your lordship.
This petitioner is a widow of
Para 10 and 11.
Yes, this one submission. My proceedings for grant of probate not yet attained.
It is pending.
The second observed.
High Court is observed that second appeal is pending.
No, they ordered the possession. I have to deliver the. It's a small piece of land. It's 50 square.
You are not.
No, that's ideally
not at all connected.
Second appeal ought to have been
not at all connected. You claim to be second wife. The wife of Madhukar plead it is son of Balu. And that is, there is hardly any proof of this.
No, but the bill is there, my lord. By the father-in-law.
By the
father-in-law, that bill.
We are not trying to entertain the SLP.
Just one more.
However, the dismissal of any observation in the impugn order or dismissal of SLP will not affect the proceedings in second appeal, which the petitioner has preferred against the order of revocation of probate.
Well, with the two orders, there's a decree against me, and there's the order for
There is a decree. That those will be examined on its own merits. It will not affect. You will not get. You see, if you insist on merits in this SLP, then you will be a loser. I am telling you.
Lease submission. Both the second appeal ought to have been heard together. That is relating to the same subject property, my lords. That's
you should have prayed it before the High Court. You should have prayed it that let it be decided. There should be an application for clubbing and tagging. How you cannot raise a ground? Sorry, next dismissed.
22. In the meantime, the position.
In the meantime, petition is dismissed. Next.
Wait, please. This Honorable Court has consistently held, my lord, where there is compassionate appointment because it's an exception to regular appointment, it must scrupulously follow the scheme, my lord. Please appreciate in this, my lord. Here, the competent authority, the learned single judge, the division bench, all have concurrently held that this gentleman's mother is employed in the same panchayat. She is drawing a salary of over 34,000, on top of which she is getting a pension. About 50,000 rupees is coming monthly. Now, please see in the review, it's been overturned. Concurrent findings of three authorities have been overturned. And on what basis? It says reliance on the Tehsildar certificate.
Sweeper, dismissed.
My lord, there is a problem.
Sweeper, you come to Supreme Court against a sweeper.
But his own mother is employed in the same town panchayat. My lord, please appreciate, my lord, because it has recurring financial.
Is there any delay?
56 days.
Yes, delay condoned. However, in the facts and delay condoned upon hearing and counsel for the petitioner, and in the facts and circumstances of the case, we are not inclined to entertain this SLP. First of the question of law is kept open. Next.
21.
The High Court has not examined
23. Yes.
In the matter, the High Court has not examined the legality and validity of the notification law. The notification law, which
you having participated, and now after 4 or 5 years,
and the validity of the condition law.
That was the COVID-19 relaxation. Now that relaxation again.
No, kindly see the page number 29, Lord. Page number 29 is the notification, Lord, where the condition has been imposed. That condition has been relaxed.
Admittedly, you do not have that driving license, which was the condition number 4 in the notification.
Not required as per the law, Lord. That's why the case will kindly see page number 25. That requirement was not there.
Thank you so much. Dismissed.
24.
May please, Your Worship.
Yes.
Lord, the page 7, the High Court itself records the submission.
After 16 years, you want clubbing. Sorry, dismissed. Not only dismissed. After 16 years, both the
other side also admits that the bearing, both the suits have a bearing on each other. Is the submission required by the High Court?
If both the parties are in consensus,
that's the only point. You can. It's the delay is not on my part. They have.
However, the parties would be at liberty to initiate mediation proceedings in the High Court. If you are both consenting to it, consent for everything. Next.
Of course, mediation
dismissed simply. Next.
25 letter.
Yes. 25 letter adjourned.
My laws were listed in July.
whatever you have prayed in the letter.
Very
yes.
grateful.
46.
Please.
Lord, in this matter, my lord, the Honorable High Court, my lord, has affirmed the learned single judge order only on the ground that my marks was
lower
than I was in the waiting list, my lord. What happened, Lord? See, come to the page 71, my lord. Select list. For preparing a waiting list, my lord, it was not.
We need not look into that list because admittedly you were in a waiting list.
Yes, my lord.
But since you have not secured the required number of marks as per the cutoff marks.
Yes, my lord.
You are out.
My lord, since waiting list was, with great respect, what I am submitting, my lord, since waiting list was prepared to give a chance to the second person, my lord.
The candidate who is not qualified.
Yeah, my lord, qualification is 45, my lord. Your lordship may just see the marks was 45 only. For qualifying marks 45, my lord. It was there, my lord. Lordship,
yes.
Come to page 70.
Cutoff was 50.
Cutoff, my lord, for the selected candidate, my lord. With great respect.
Whenever you are selected,
my lord,
it had to be 50.
Yes, my lord. That was
the
not
moment from waiting you are selected, you have to secure 50 that you are not selected.
No, my lord. That's with great respect, my lord. Since, my lord, the waiting
With
list.
great respect to Mr. Manoj Mishra, we are not agreeing. Dismiss.
Highly obliged. Highly obliged.
Yes.
Lordship, I see pass over.
Pass
The
over.
council in the Abetment has legs on court number 1.
Eviction, yes.
Grateful.
28.
Yes.
Having been made me to work for long 15 years.
Long 15 years.
As an executive officer.
You have never worked as executive officer in substantive capacity.
No,
you never had any lien in that post.
No,
how can you be granted pension for that
substantive capacity in the sense, it was an appointment by way of deputation because that was a regular.
You were never absorbed. Your earlier writ petition for absorption
now,
was dismissed.
Lordship may kindly see
Everything is against you.
43 onwards, Lordship may kindly see, all other people, those who have been appointed along with me, they have been. After their superannuation, they were absorbed and they were given.
Unnecessarily wasting your time and energy.
Maharaj, may kindly see.
You meant your part.
43 onwards, may kindly see. All my colleagues, those who were appointed by the same order as an executive officer or centralized cadre, they all have been subsequently after their superannuation for the purpose of retirement benefit. Having worked for 38 years and now have been sent back to the initial position post of posting.
Because you were on deputation, you were repatriated.
No, but all
you applied for absorption.
Not all others.
That was refused in the earlier round of litigation.
All others have already been given that 43 onwards.
Sorry.
Not
Dismissed.
all the orders.
You have never worked. Next.
I worked for 97 up to
Please.
superannuation. I was executive officer, my lord, centralized cadre. And my lord, and all other Rati, the one who was page 27, 28.
If a Tehsildar is made to work as deputy collector or in the officing capacity for 2-3 years, then he will claim.
This honorable court time and again has
This
said,
honorable court has not done anything
you
of that
can't
nature ever.
You can't having taken services for long such period and then you deny retirement benefit.
Yes, next.
29.
My lord, this is a case where the issue is whether the respondent, who's a married daughter of the deceased government servant with a surviving brother, was entitled for the compassionate appointment as per the rules of 1996. Because the 1996 rules.
That is how it has been interpreted in the full-bench judgment of the High Court.
My lord, that is.
Followed that.
My lord,
full-bench judgment.
But my lord, how can it be retrospective be followed? My lord, that is a scene, my lord. That has not been.
High Court has full bench has said.
My lord, I agree that.
Followed in all pending cases also. Sorry.
My lord, delay may be condoned, my lord.
Dismiss.
My lord, delay may be condoned.
Yes, we have condoned the delay.
Grateful, lord.
Is your lord.
Yes.
I have established my immunity right, Lord. There is no other way.
Today you have a bad case.
Not this is not.
Today this is also.
Listen, my lord, kindly. My lord, there is no way to, my lord, approach get number 20.
Right of way. You file a suit. Liberty has been granted to you. High Court has granted you liberty.
No, there is no.
Yes.
Even there was in the Mamata.
No, there is no liberty here.
Yes.
But it establish that
No, no,
parties are at liberty to establish their, I'm sorry. Liberty.
Liberty is
Yes, liberty. But kind of, now the monsoon, now the season is coming. There are to sowing operations. There is no other way. But the easementary right, how do we establish? Two authorities are held in my favor. Tahsildar, SDO.
It's a Mamata court only.
But it's
very limited power.
High Court has exercised 227 supervisory. It's a finding of fact.
Only when
I'm sorry.
6 months you have been dispossessed of that rasta, then Mamlatdar has power. But you see, when you claim right of way as an easementary right, Mamlatdar court has no power. Only civil court can do that. And that liberty has been granted to you. Please avail that liberty.
This is I'm living there. This agriculture, the fields. That is the affidavits of the neighboring the agriculturists. Panchanama. Two courts have
upon hearing and counsel,
one more submission.
SLP, accordingly, the SLP is dismissed. However, the petitioner would be at liberty to avail the remedy of filing of suit before jurisdictional civil court, and in such eventuality, the observations made by the High Court under the impugn order shall not come in the way of either of the parties, and the suit shall be decided on its own merits expeditiously. If you file it expeditiously.
Yes, we'll do it, Bulat. But till the Bulat is some
more than
they consider my application for granting of Bulat this way until the disposal of the suit, Your Lordship.
One word about interim order in your favor will amount to allowing your suit.
Some observations in the suit proceeding.
Petitioner would be at liberty to apply for
Please,
interim relief before the civil court. Yes, next.
Grateful.
31.
Lordships, this is a legal aid assignment.
Legal aid.
Order dated 20th March of 26. The petitioner was directed to surrender.
You have surrendered or not?
No, Lordship. This morning only we have received instructions from the Legal Service Committee. If I may pass over the emails that we have received.
So what is that?
Lordships, as per this morning, the petitioner has not surrendered. We sought time to seek the necessary instructions in this regard.
How much time?
Lordships, 4 weeks time. Maybe.
4 weeks time.
Yes.
You want more?
No, Lordship. We'll seek the necessary instructions.
No, not instruction. For surrender.
Lordships, we haven't been able to get
we can grant you 4 weeks, 6 weeks also, 8 weeks also. If you want more, we can grant you more time.
As the Lordship deems fit, Lordship may
as paid by learned counsel for the petitioner, comma, as paid by learned counsel, comma, petitioner is allowed 8 weeks time to surrender. He shall surrender before the trial court or the concerned police station on or before this 20 on or before 22nd July and submit surrender certificate. If the petitioner fails to surrender, the SLP shall be dismissed automatically without reference to the court. You understood why? Yes, I said you want more.
Yes, Lordship, I understand.
Now it is ball is in your court.
Much obliged.
Yes.
32.
Petitioner is a lady, she was A2, under offense under 402, 449, and awarded life and 10 years in prison.
It is a case of circumstantial evidence.
Yes, pro bono litigation,
Issue notice.
Delay may be condoned.
Record of the trial court delay condoned. Issue notice. Record of the trial court be summoned and disguised copy of the trial court record shall be supplied to learned counsel for the parties at their request. Next.
Grateful.
Please, Your Lordships, there's a very short issue raised in this matter. I straight away have page 5. Your Lordship,
Nothing.
Your Lordship, allow me to
Absolutely
read
nothing.
one paragraph.
Absolutely nothing in the
Your Lordship, just allow me to read one paragraph. Going through the impugned orders and the averments made in the petition, it appears that the petitioner had filed the complaints under so and so.
Absolutely bad.
Whereupon the learned magistrate ordered enquiry under section 202, directed police to conduct investigation, submit report. However, no concrete investigation being done, and police officer has submitted the report without collecting sufficient material, though without considering the said fact, learned magistrate has committed an error in considering the fact that there was negligence on the part observing an error. Your Lordship, how can the order of the magistrate be upheld after the High Court observes there is an error?
You see, all the courts, magistrate, sessions court, high court, concurrently found there is nothing in your complaint.
Your Lordship's
It's a civil matter.
section 2.
Sorry.
Your Lordship, there is an error committed. Your Lordship's may just issue notice, hear me.
Your Lordship,
Lordship,
hearing you.
allow me to take you to the order. Allow me to take you to the order which dismisses. There is an incomplete inquiry. Your Lordship, I'm an elderly lady. I'm senior citizen. I'm uneducated.
No, but there must be some offense made out.
Your Lordship,
Merely because you are a elderly lady, we cannot issue notice.
my lords, there was someone has induced me into opening a
Sorry,
bank account.
dismissed. Nothing.
34.
May it please, my lords.
My lords, if I may be allowed to withdraw the same.
Yes, dismissed as withdrawn. Next.
May it please, my lords. So by virtue of section
There's a delay.
98,
Yes.
my lords. So by virtue of section 98 of Gujarat Prohibition Act, the vehicle stands seized by the concerned authorities. What has not been seen by any of the courts below, my lords, is interplay of section 99 proviso, which grants a benefit, my lords, to a person who can show his bona fide that he had no role to play in the offense, my lords. So now, my lords, I am the person.
You are
So,
owner
my lords,
of the
I am the owner of the vehicle. Neither been investigated in the FIR, my lords, nor in the charge sheet my name is there, my lords. Not even in column 12 I am there, my lords. So no offense against me as such, my lords, has been registered as on date, my lords. Neither any pending investigation. So my lords, all that has been done was an isolated infracting act by the driver, my lords. And this has resulted into the confiscation of the vehicle itself, my lords. In that very vehicle, my lords, my edible goods worth 1 crore were there. And that also stands released in my favor. So whatever has been done, my lords, it has been done at the behest of the driver. I have not been taken.
But vehicle can be confiscated at the end of the
May I stop
litigation.
you, my lords? The confiscation, my lords.
Even if you are not a party, if the vehicle is found to be involved in this offense under the Prohibition Act, the vehicle can be confiscated.
So, my lords, there is an interplay of two sections, if I may read those two sections, my lords. Section 98, clause 2 of the Prohibition Act, my lords, give the power to confiscate, whereas 99...
Notice.
I'm so, my lords, there is delay of filing and filing. So grateful, my lords.
Notice returnable on 19th August.
I'm so grateful. Deeply obliged, my lords.
Yes. 35 notice, letter adjourned.
36.
Please, my lords. In item 36, my lords, an FIR is registered on 4th of June for disproportionate assets in excess of rupees 80 lakhs, cash of in excess of 22 lakhs is recovered, my lords, gold in excess of 16 lakhs. If 16 days later, my lords, the quashing petition is filed.
Is it connected with that Prashant Kumar case?
My lords, this same judge on near identical grounds has issued notice in that case also. And it said so in my pro forma also. In this case, my lord. Where notice has been issued because, my lord, this order has to go in my respectful submission. Nascent stage of investigation, my lord, the entire
notice
is quashed. My lord, I have one request.
If my lords,
you are appealing?
Yes. Yes. My lords, may kindly see the information. My lords, at page 75.
You file counter.
My lords, I have one request. Pursuant to me filing the SLP, the matter was pending before the special judge qua attachment of properties. Now, solely on the ground that the FIR has been quashed, the attachment has been directed to be released and the bank accounts unfrozen. Now, my lords, now it will be open to the petitioner to deal with all those assets. So I'm praying for status quo, my lords. I've got that order.
The vicious nature, I'll explain.
The release of the attached property shall remain subject to final outcome of this SLP.
Let's make just one thing, the vicious nature, the prosecution minutes. There was a departmental inquiry, a minor punishment was imposed. That was challenged before the Honorable High Court, that was set aside. But that was not implemented, no promotion benefits were given. Then contempt was initiated. Within 48 hours, they come up with this one. My lords could see the complaint. It's a journalistic language, credible information. We have come to know it is learned reliably. These are the things. The Honorable High Court has said, where is the source report? If that is there, you go ahead. You can't just create something out of thin air and say that somebody has to face the prosecution. This is what's been said.
In similar case, we have this notice.
I just would like to put
Notice accepted. Notice accepted. Mr. So-and-so and counsel accepts notice, appears and accepts notice for respondent, posts the matter, let counter affidavit be filed and posts the matter on 10 September.
Great.
Yes, next.
Great.
Letter.
Adjourn.
The petitioner has already undergone more than 23 years of incarceration, my lord. That is the main thing. Otherwise, it's a case of human sacrifice, my lord. I will not argue.
No, why are you not released on remission?
Yes, my lord. Till date, it's a legal services committee matter, my lord. So
it is
give the observation, my lord.
Jail.
Yes, my lord.
Since more than 22 years.
Yes, 4/10/2002, since 4/10/2002. In between, my lord, for 25 days he was on bail, my lord. That's all.
Petitioner is in jail since last more than 22 years. Let copy of the SLP papers be served on the Standing Council for the State of Odisha, who shall seek instructions as to the status of petitioner's eligibility for premature release of legal remission. Post the matter on 10th August.
Problem.
Yes, next.
39.
Yes.
My lord, I am appearing. My lord, in this matter, the Honorable High Court has outrightly rejected my quashing.
Yes.
But the premises is, my lord, that under the Act, the Muslim Women Protection Right Marriage Act, talaq has been defined. And there talaq means talaq-e-biddat or any similar form of
that
talaq.
That is all subject matter of evidence what High Court says.
But
that
my lord,
whether notice were issued during successive to hers and whether there was an intercourse during the relevant period.
My lord, may kindly see.
Matters.
My lord, may kindly see for a minute only the FIR filed by her. In the FIR at page 51 of the paper book, page 70.
It is not once charge sheet is filed.
No, my lord, here in the FIR, in the complaint,
we have to see the entire charge sheet. It is not the only FIR. All the materials will be seen.
My lord, here she says, I am staying away from my husband. And 3 different notices in 2 months have come. She herself says, my lord, may kindly bear with me. Let me just point it out, my lord. Page 51, annexure P9. As my husband and family members driven me out of the house of my husband, I took shelter at my father's house with my daughter. Neither my husband nor family members came, but they were still harassing me. In the meantime, my husband sent notice on 1st, 2nd and 3rd notice of talaq, that is on 20th March 23, 24th April 23 and 31st of May 23.
Sorry, let the trial go on.
My lord, all I am praying, my lord, he is a CISF constable. My lord, here it is not qualifying as per the meaning of talaq under the Act, my lord.
To divorce doesn't apply differently if he is a CSI or he is a businessman or he is a doctor.
No, my lord, I understand, my lord.
40 letter. 41.
Oblige, my lord.
Make it.
40 years. Letter adjourned.
41.
41.
Co-accused Lordship already issued notice in 41.
41. Why? Why have you issued notice?
Lordship, same rule as the co-accused for which my lord have already entertained.
Notice tag with SLP diary number 60926 of 25.
Lordship, delay may be known.
Delay control.
And Lordship, Lordship's last order was that copy of TCR may be supplied to the council for the appellants. Lordship, same order for.
Same order.
Grateful.
The TCR. Just. No, in that case, in Saurabh case,
Lordship,
there is no such order.
Lordship, the last order in that case, Lordship,
First order is of 4/12/25.
Lordship, 19/5/26. Let digitized copy of the record of the trial court be supplied to learned
Trial
counsel
court
of the parties.
be summoned, and the digitized copy of the same be supplied to learned counsel for the parties at their request. Yes.
Grateful, Lord.
What do you do? Let me grant a short passover. I have been led by senior advocate S.K. Gangili.
Passover.
What is the
I've already undergone the conviction in the High Court. They have challenged the conviction order, Lordship. Petitioner has already undergone the entire sentence. Petitioner has already undergone the sentence, Lordship, in this matter. He is only challenging his conviction in this matter.
But where are you in the impugned order?
I am kindly see DW.
Amarpal versus state.
Amarpal, yes, I am in Pulender and Balish.
Pulender is not there in the impugned order.
No, he is here, Amarpal.
Where is he?
Kindly see. Along with criminal appeal number in the bottom, counsel for the respondent. Criminal appeal number 3515.
These two criminal appeal.
Two criminal appeal.
Where is the order in your criminal appeal?
Well, it is the same, the common order, Lordship, in both the matters.
So how do we know you are there? In the other criminal appeal also, there is no cost title.
We have filed the cost title of the High Court, Lordship.
No, there is no cost title of the High Court. Page 1 of it only says Amarpal.
Yes.
And you are not Amarpal. You are.
I filed the Lordship the criminal appeal of the High Court petition in the annexure P4, Lordship. Annexure P4 is the cost.
In fact, we should amend the rules by saying that in Supreme Court, certified copy is not required to be filed. And if anyone files the certified copy, that SLP will not be entertained.
Yeah, these are certified copy. But you know, in the High Court order,
no one files it.
There is no certified.
Petitioner is directed to file certified copy of the impugned order of the High Court.
But certified copy, this is certified.
No, there is no certified copy.
Kindly see.
Post the appeal on 3rd August. Next.
Kindly see P4.
There is no certified copy.
But this, in the bottom, it is shown it's a certified copy, Lord.
No.
These are certified copy, Lord. Because
let us see P4 page.
P4 is the P4, Lordship.
Yes, page.
Page number, Lordship, page 72. 72. In the High Court, you get a criminal appeal. But these are a criminal appeal, Lordship. P4, page 72.
No, 72 is an extra P4.
P4, yes, sir.
ST number so and so.
Yes.
No, this is an appeal memo.
Appeal memo, yes, sir.
Judgment. Where is the judgment? In your case.
This is sub-judgment in this case, Lordship, also. You are not see there
is no cost title showing your name.
In Allahabad High Court, there is no cost. This is a limited.
You have filed any application for it?
So there is no page number 8.
From filing certified copy?
No, not.
Petitioner has neither filed certified copy of impugned judgment of the High Court nor filed any application seeking exemption from filing certified copy. Therefore, the SLP is not properly constituted. It is accordingly dismissed with liberty to move a duly constituted SLP afresh. Next.
Kindly see page.
No.
Kindly.
No.
Certified copy.
Sorry.
Madam, kindly see page 8, Lordship. This will be effect by kindly 8, my lord.
What it will effect? We want it to defect.
No, but page 8 is the certified copy. I have to be justified to the client, Lordship, because page number 8 is the High Court of Judicature.
No, you are justifiable to us first.
Page number 8, Lordship.
Forget your client. Page
8, Lordship. Page 8. Page is the bottom, High Court of Judicature, computerized copy section. in Allahabad. This is the. I will find my lord on the memo along with the memo party. This what we have received. To find the memo parties also.
Learned counsel for the petitioner is permitted to file the certified copy of memo of party of his appeal, which has been decided by a common order, by a common judgment under the impugned judgment of the High Court. Post the matter immediately after partial working days. Yes, next.
Okay. August, it is better. In August, it will take time in taking certified. In August, but not in August.
No, you will get it.
It will take time.
Web copy you can get.
There is also holidays.
Web copy you can get.
In August or not, it will come before not civil.
We have done it. You are in jail.
No, I've already undergone.
So why have you filed this SLP?
Well, only I'm telling you only conviction, not
conviction. You want to become chief minister?
Not chief minister.
Then?
Well, keep it in August. I
already suffered someone. Why to unnecessarily file SLP? You better
in August, not keep it.
There is nothing. It's an open and shut case.
Then I will take my.
Yes, next.
After 2 weeks, okay.
Lord, this summoning order does not satisfy the test mill order. Laid down mill order in the constitution, Gibson mill order.
Rape,
page 54.
So aggravated sexual assault, and you want discharge.
Lord, the prosecution, the investigation agency mill order. After material, the collecting material or record mill order. Page 52 and 42 and 43.
You were named in the FIR, yet you were not sent for trial.
I was found 300 kilometers away, and see page 42 and 43. For a moment.
Issue
42 and 43.
Issue notice to the respondent. Full stop. Issue notice also to the concerned investigating officer who did not send the petitioner for trial despite his name occurring in the FIR in an offense wherein the prosecutrix has alleged forcible sexual intercourse by him. Anything else you want?
Lord, I heard.
Now he will be in jail, I am telling you.
Lord,
this IO will be charge seated. Because of you,
Lord,
this IO will be charge seated.
My Lord, absolutely.
I am telling you. I am telling you 201 and other sections.
If the material
is attracted against the IO.
Lord, yes, Lord. He should be if the material is found to be incorrect, Lord. He should be. But if the material he collected, Lord, it is the correct material, Lord.
We also direct the DGP Punjab to examine the matter and issue departmental inquiry against the IO after giving opportunity of hearing to him. The action taken report shall be filed by the DGP before this court on or before 15th August, Independence Day.
Yes.
Anything else you want?
Lord, I only pray, Lord. In the meantime, Lord, has please to initiate investigation, Lord.
The DGP shall also initiate separate investigation against the IO. Anything else? And if need be, the IO shall be arrested. Anything else?
We'll stay of proceedings, Lord.
Sorry, सबको काट देना. Dismissed. SLP is dismissed.
Lord, only one prayer.
Delete everything.
Lord,
Yes.
Lord, I'll surrender, Lord. Lord, she may consider my bail, Lord, because it's 6 years.
I think
Lord,
not a case. You're Mr. Counsel. You're Mr.
Swag.
Mr.
Surjit Singh.
Surjit Singh.
Yes.
Barnala.
No, yes, Lord.
Mr.
Of course, Lord. He was also advocate.
Not a case for pressing.
No, Lord,
we are telling you, we have read the paper.
Well, only my prayer is, Lord.
Not a case.
I'll appear, Lord. Lord, she may grant me bail, Lord. Because 6 years I Lord pending.
You apply for bail.
No, that's one word.
SLP is dismissed. However, it will remain open for the petitioner to apply for regular bail or anticipatory bail, as the case may be.
Milord.
Yes, next.
Consider sympathetically.
No.
45.
Yes.
May it please your lordship.
Yes.
I'm sorry, my lord. There seemed to be some problem with the video, my lords. If I could address it, my lords. There are 3 accused in this matter, my lords. Accused number 2, Prashant, has been accused of attacking with a knife. Now, my lordship sees there's contradictions between the statements of the witnesses. PW1, who was the eyewitness, says that all the weapons were found on the ground, on the spot, my lords. PW2 and PW6.
How much incarceration you have suffered?
More than 11 years, my lords. All 3 of them have suffered more than 11 years. I have been told that accused number 3, my lord, Pradeep, is very unwell. He's been vomiting blood for the last several weeks, my lord. So more than 11 years, all 3 of them have been in prison for more than 11 years, my lord. There are a lot of contradictions between the statements of the witnesses.
Enough evidence against you.
No, my lords, there's a lot of contradiction between the evidence, my lords. PW1 says the weapons were found at the spot, but then PW2 and PW6 says it was on the thigh of the deceased. Then they recover the knife from a field, my lords.
Read the statement of eyewitness.
Yes, my lord. Your lordship will kindly see PW1, page 45 at 50, my lords. Your lordship sees page 50. At page 50, para 14, my lords. If your lordship sees page 50, para 14. At 1 a.m. on the day of incident, about 7-8 policemen came on the spot. Axe, knife, sickle and 2 rods were lying on the spot. Then if your lordship sees PW2 at page 57, my lords. PW2, page 57, if your lordship sees, the second last line, my lords, have it. There was knife found in the left thigh of dead body, my lords. Which also PW8 at page 75, my lords. At page 75, if your lordship kindly says page 75, that is page 75, it says that he confessed about the commission of the offense and showed his readiness to produce the knife. If the knife is on the spot or on the thigh of the deceased, my lords, how can he can show the place where the...
If you read paragraph 2 of the deposition of the eyewitness at page 45.
Yes, my lord.
He has given a vivid description. The broad daylight murder by all the persons.
My lord,
he has mentioned what weapon was carried by which of the accused and who assaulted first, who assaulted later. Everything is there. And you say that since weapon was lying in the open place, now the eyewitness has to be disbelieved. Sorry.
My lord, there were a lot of contradictions. My lord, one simple humble request, my lords. One humble request, my lords. Accused number 3 is having a lot of medical issues, my lords.
However, the petitioner would be at liberty to apply for remission of the premature release as and when they become eligible. Yes, next.
My lords, he is sick. He is not unwell, my lords. He may be permitted to apply for medical parole or furlough, my lords. He is vomiting blood, I have been informed.
That is your right. No direction is required for that. Next.
My lord, delay may be kindly be controlled, my lords.
May it please, my lords.
Yes.
Item 46. It is a petition to quash the criminal proceedings, my lords. Admitted, it has been 14 years, my lords.
You go for discharge.
My lords,
yes.
I may be 71. My lords, in 2012, I filed a civil suit. Admittedly, I have
liberty granted to you.
My lords, but it is not a case for trial, my lords. Let me submit, my lords, only one page from the charge sheet. The lordship may kindly come to the charge sheet, my lords. The finding at 107, only page 107, my lords. Admittedly, 107, my lords. Admittedly, the injunction is in my favor, and there are disputes, civil disputes between petitioner, A1 and de facto complainant. My lords, in the due course of investigation, I am not even named in the charge sheet, my lords. No way. In the due course of investigation, came to the light that the accused number 2 is a kingpin for the heinous offence. He may engage 15 to 20 hired gundas from Rajahmundry to eliminate the complaint, got to so-and-so village on 3 cars, including so-and-so at 3 p.m. LW1 and his friend LW2 going on car when reached so-and-so.
You are Sunkali Varaprasad.
Yes, my lords. I am Sunkali Varaprasad.
You have been sent for trial.
My lords.
Others who were not involved, they have been let off by the IU. That's a fair investigation.
Correct, my lords. But I may be pointed only one thing, my lords. Even in the charge sheet, there is no allegation against me. There is no role attributed against me, my
You
lords.
see, it is 307, 323.
My lords, but there should be
assault, criminal trespass,
my lords,
everything is there.
No trespass, my lords.
Criminal
323, 341, 307, out of which all punishments are 1 year, my lords. Only
307, 1 year.
No, my lords. Only 3. I'm just submitting, my lords. Only 307 is there. That is 10 years.
Not a case for passing.
My lords, for trial, there should be something in the charge sheet, my lords. The charge sheet is totally absent about me. Your lordship may kindly appreciate. If there is charge, my lords, out of
what is the evidence against him?
Yes, my lords.
My lord, kindly turn to page 103, my lord.
103.
103. On 23/6/2012, evening accused along with so-and-so, along with A.T. through A11 and others at Katravulpalli form themselves into an unlawful assembly. Then they go to the next village. They waylay the man on the road. Acts in the public interferes and then catches him. There is enough evidence, my lord, and as my lord rightly pointed out, for 14 years the matter has been held up, my lord. Discharge is already there. Your lordship may direct the lower court to discharge.
And Mr.
Here the discharge within 30 days.
For the respondent.
My lords, only 104.
Respondent number?
A42, A7 were caught, my lords. I was not caught, my lords. My lords, wrong facts, my lords. Kindly see, my lords.
You are appearing for which respondent?
I'm for two,
Respondent number 2. For respondent number 2, we are not inclined to entertain the SLP. Accordingly, the SLP is dismissed. However, the liberty reserved in favor of petitioner by the High Court.
14 years trial has not started, my lords.
Yes, that is my, one of the complainants has already died, my lord, because of the delay.
Then nothing remains.
Argue at the stage of framing of charge is kept intact. Yes.
One request.
Yes.
It is not their petition, my lords.
It is your SLP.
No, my lord.
You go and convince the trial court.
My discharge petition will be.
Or file a separate 482 petition in the High Court for expediting trial.
My discharge may be dealt expeditiously, my lords. That's only the
yes, my lord.
Only request. Only request.
Why are you helping them?
It was 14 years, my lord, the trial got stuck. One person has already died.
That will help them.
Discharge, my lord. There is nothing in this, my lords. If there is something I would have considered to your lordships, my lords. There is nothing, absolutely nothing.
Since both the parties are requesting for a direction to the trial court to expeditiously decide the matter.
No, my lord, discharge, my lords, not the trial, my lords. Asking discharge, my lords, my SLP.
Yes, yes. The trial court shall do well to expedite the trial, including petitioner's prayer for discharge.
Yes. Obliged.
Everything is there.
My lords, trial expedition, my lords, nobody.
No, everything is there. Well, we accept your prayer for expeditious disposal, we accept their prayer also. Yes, next.
Great.
Obliged.
Next.
I'm wife and daughter of the deceased man.
Wife and daughter.
We have been living separately since 2009. For my daughter's wedding, my lord, we have taken some money from him. Now he's committed suicide 1 week thereafter. Now there is a
how can the FIR be quashed?
My lord will just come to page.
Let the at least investigation be completed.
Just
and apply for discharge.
My lord, just see page 106 for a minute, my lord. If my lord will come to page 106. Last 5 lines, my lord. It says, last 4 lines. Wife Aruna and daughter had blackmailed him, and wife so and so had blackmailed for 10 lakh, and daughter had blackmailed for 7 lakh. My lord, this cannot be an instigation for suicide, my lord. It cannot, by no means, my lord, even if it's taken as prima facie, my lord, it can't be an abetment to suicide. And after this, my lord, he commits suicide after more than 10 days. There should be proximate nexus with the date as well as the date of the occurrence, my lord. There's no proximate nexus at all.
Who are you? What is your relation with the deceased?
I'm the wife and the daughter, my lord. No.
Your wife and daughter of the deceased?
Yes, of the deceased, my lord. It is said that we have taken money from him.
Where is the suicide note? Which page?
My suicide note is because the charge sheet is still not filed. But what I read out to my lord is the FIR, my lord. My lord may ask the state to produce it because a suicide note has not been given to me, my lord.
If you notice, returnable on 18th August.
Great to know.
48.
Arguing counsel is on VC in 48.
My lords, in item 48, the lordship will see the impugned order. There were 2 appeals which were filed against the impugned order of the learned session judge. And the two appeals will also see the page 85 on I'm on the procedural part, they are to be heard together. And the Lordship, one appeal got listed, filed by the state, and which has been decided, my Lordship, it will have an impact on my appeal pending 1031. That's the short and issue number one. Number two, even if Lordship goes on merit, then I can.
No, but why are you praying now? You should have make a request to the High Court when the matter was argued.
Because they have, Lordship, they have already decided on merits. They have already decided on the merits. This appeal, then there is no power of review of their own judgment, my Lordship.
No. Before
that is why I come before you, Lordship.
Made a prayer. Before the impugned order was passed by the High Court, you should have requested the High Court that there is another matter pending arising out of the same order. You are not audible, Mr. Dubey.
Am I not? Yes, my Lord. My submission is, my Lord says, because this judgment has been passed in my absence, now the review, as far as the review is not available, how do I have to come only on the SLP, my Lord says, against the final judgment. My Lord may see this is the final judgment. This is the final judgment passed by the Honorable High Court, my Lord. My Lord, see this. This is finally disposed of the appeal which has to be heard together.
How can
yes,
you file an appeal?
Yes, my Lord. Yes, I have filed.
You are not a party.
Lordship, see the order. Lordship, see the order at page 85.
You are not a party
Page
in the
85.
appeal in the impugned order. Yes.
Please connected appeal. Both Lordship, this is page 85. Where it is page annex P6. I can come, my Lordship, or can have on Monday, my Lords. If there is connectivity, I can come, my Lords.
In the audio-visual system of Learned Counsel appearing for the petitioner post after partial working days. Next.
49.
Your Lordship will present
Yes.
a short passover in this matter. Okay.
Yes.
The solicitor is he may be unmuted.
What?
The solicitor
My Lord,
is
here the impugned order is also challenged by the other side. And we are also challenging the very same order. The request is, my Lord, both may be tagged and heard together, my Lord.
Where is that?
Lord, I'll give the number, my Lord.
Any diary number?
SLP civil 555.
No, that notice is issued.
Lord FG informs, appearing for the petitioner, informs that who has passed the preferred the other SLP name of the petitioner.
Lord, Sevok, SEVO, Sevok Properties Private Limited.
Sevok Properties Private Limited has also preferred SLP diary number.
No, SLP number 5522.
So it is SLP number, my Lord. 5522
of 2026.
Yes, ma'am.
In which notices have been issued on 27/2/2026. Full stop. In view of the above, issue notice of this SLP to the respondent, tagged with SLP Civil 5522 of 26.
Please, Lord.
Yes.
I will file my counter, my lord. I will file my counter. I am credited.
Respondent shall file counter before the next date of hearing. Next.
Please, oblige.
You will accept notice?
Yes.
Mr. So and so, Learned Counsel, would accept notice and undertake to file counter before the next date of hearing. Yes, next.
66.
In 66, with respect to the same landlord at page 64, there is an SLP pending here, Manoj, on the contours of section 13B, which is the provision that he had invoked in order to eject certain other tenants. That matter is currently pending because the Punjab Haryana High Court, in fact, held against the landlord in that petition. And then the landlord, the same landlord, filed an SLP at page 64. The case status is at page 65.
So, how are you concerned with them?
Because that
there may be several tenants, several landlords, all are separately contested. Mainly because it's one in the SLP of one of the tenant.
Yes,
notice is issued. It is not that in every tenant's SLP the notice.
The reason is that he has invoked section 13B, which is a provision pertaining to NRIs. Now,
here you are facing, you see, you are suffering all the concurrent orders by all three.
Yes, my lord. Yes, that is there. But since the similar issue is pending here, my lords, because 13B, my lords, may
Sorry,
I just
dismiss any time you want.
May I just indicate, my lord?
Any time you
This
want.
is a commercial which he's
Time you want, 3 months, 4 months, 6 months, whatever.
Not the same provision, not the contours of the same provision, because what is really there is whether that bona fide necessity can be demonstrated, especially when he has 10, 15 shops and he is going against all of them. And then he doesn't disclose
Time has changed.
Petition.
2-3 decades back.
Let me just see page 8 for a moment, my lord, of the include order. Page 8.
Yes, what is that?
Lord, the High Court relies upon Baldev Singh Bajwa, which is a judgment pertaining to 13B. Now, the same 13B is invoked by him in that other.
No, in every case of bona fide notice necessity, 13B would be invoked.
13B is a special provision arising only in Punjab.
Sorry, concurrent dismissed.
May I just seek a password just to seek instruction on how much time they will give me? Just to
you come and inform. Yes. Password nahi hoga na. Order is passed. You only inform about the time.
Yes.
If you want. Yes.
Let me also consider if mediation is possible, because the landlord is eventually selling these plots to third-party purchasers. If there could be a limited notice on mediation, just that. I'll come back and find this.
Yes.
68.
My lords, I am appearing in item 68 for the petitioner.
Yes.
My lords, I am seeking anticipatory bail in connection with crime number 64 of 26, police station Shamlal.
Yes.
My lords, as per the FIR, 3% has robbed one doctor.
Yes.
And took the gold bracelet from his hand and some amount. My lord, all the three accused has already been arrested. On the basis of memorandum, my stepsister was arrested. When I accompanied my sister to the police station, the police has asked me to pay rupees 5 lakh. And when I refused to give the amount, they have implicated me in the present matter, my lord. My lord, I was not even present.
See, at 10 AM, you are throwing chili powder in Bhopal.
No, my lord. My lord, all the three accused has already been arrested. I am seeking an anticipatory bail.
Anticipatory bail in a case of this nature, in broad daylight. Sorry, dismissed.
My lords, I was not even there, my lord. My lords, kindly see the FIR, my lord.
Dismissed. Go, you will be released immediately.
69.
Please, my lords. My lords, this petition is for the anticipatory bail of the husband, my lords.
Yes.
After having 5 years as relationship before marriage and 7 years of marriage, my lords. My lords, disputes that arose between the parties. And my lords, the husband, the petitioner, files the divorce petition in 2022. My lords. Thereafter, my lords, since 2024, my lords, the respondent wife has been filing multiple cases against the husband, my lords. And my lords, in 2025, she had also, in March of 2025, much obliged. Interim protection may be
returnable on 1st September.
Interim protection.
Meanwhile, petitioner shall not be arrested in FIR number.
Much obliged.
Next.
May it please. So this comes to your lordships after notice. Your lordship had issued notice on 17 February 2026. May I place that order?
Yes. Counter is filed.
Counter is filed. It's on record. I wish to place two things before my friend. I'll just place the order and my friend has something to say. I want to respond to that in my submission. When it comes for the petition submit.
Suspension of sentence is rejected.
Yes. Now, the submission is for the petition submits that the deceased did not receive any injury over his head or any other sensitive or vital part of his body, and the death occurred due to complications from the injury. However, the trial court, while convicting the petitioner for offence punishable under 304 Part 1 of IPC, has sentenced the petitioner to undergo life imprisonment. It also submitted that the appeal before the High Court is of the year 24, and therefore there is no possibility of the appeal being.
Use mic, speak loudly.
I'm sorry. I'll read it again.
Yes.
Learned, the petitioner submits that the deceased did not receive any injury over his head or any other sensitive or vital part of his body, and the death occurred due to complications from the injury. However, the trial court, while convicting the petitioner for offence punishable under 304 Part 1 of IPC, The sentence.
But let them come. Unless they come.
They are here. They have filed their.
May it please, my lords.
I want to show two things before my friend responds. Kindly have page 180 with me for a moment.
Yes, you have undergone how much?
5 years, Guru. 5 years and not.
Yes, Mr. Raja.
May it please, my lords. My lords, may kindly have page number. My lords, may kindly have page number 126. There are 22 odd injuries on the body, my lords. The man has been slaughtered literally, my lords.
Yes, 121.
22 injuries, my lords.
Yes, and
3 pages of the petition, my lords. 3 pages of the petition have been dedicated only for the injuries.
Yes, now please see the injuries.
Page.
Injuries
Page 126 it starts, my lords. Page 126 it starts and travels till 128. So to give details of the injuries, my lords, 3 pages has been dedicated in this very petition.
Yes, now please see the injuries. My friend should also.
May I submit? If my
the
learned friend may allow me to speak, my lords.
My friend should also point out.
I'll point out, my lords. I point out for everything from the SLP, my lords. I won't shy away from stating anything, my lords. Indeed, he has undergone 5 years and 8 months, my lords. But it's a case of conviction of 304 part 1 with life imprisonment where the intent is clearly reflected, my lords.
Sentence is life.
That's the submission.
Life, my lords.
304 part 1 and now please see why life is
so
given.
Intent is clearly been reflected from the 22 odd injuries, my lords, that have been inflicted. In the dying declaration, the first Dehati Nalishi has been treated as a dying declaration. His name has been reflected there. Name is there in the FIR, my lords. The witness has deposed, the eyewitness has deposed against him. So he has no case in appeal, my lords.
Yes. Now he dies after 2 days. As far as the injuries are concerned, now please see 126. My friend should have pointed out the submission of that there is no injury on the head. High Court goes on the footing and rejects the suspension on the basis that there is an injury on the head. So that's
You see the measure of the injury.
Yes. Now please see that. I want to show that.
11 cm.
Well, kindly see. These are in the nature.
All injuries.
Abrasions.
What abrasion?
Please see. Please see.
Though it is in right arm, forearm, or this and that.
Yes, they are all preceded.
Almost 8 to 10 sutured wounds, my lords. 8 to 10 sutured wounds.
15 stitches, metal staples.
Kindly see. There are 2 submissions.
Yes.
One is on the nature of the injuries, that neither of the injuries are on the vital part. Second, they are all in the nature of abrasions or contusions. I have seen these 16 injuries. They are in the nature of abrasions or contusions. That's as far as the nature of the injuries is concerned. Now,
very brutally beaten.
No,
head injury is not required in a case of such
Your Lordship are right. I am not saying that.
You give such a severe beating.
I am not saying that. My submission is slightly different. High Court proceeds on the footing and rejects my bail that the injury is on the head, number 1. Number two, there is no specific allegation that is qua me. Number 3, 30.
Sorry, dismiss.
Look, kindly see one more aspect. One more aspect I want to point out. One aspect I want to point out. As far as the on merits, Lordship has seen the injury. On merits, Lordship has seen that there is a dying declaration. Now, this dying declaration,
that will be seen in the.
That's right. He dies 2 days later. That dying declaration is not recorded before a magistrate. There is no fitness certificate that is recorded.
Appeal
yes, therefore, I am saying there are plausible grounds.
Sorry, next.
Appeal is of 2024.
Next.
So grateful, my lords. Deeply obliged.
None for the petitioner. He's appearing in person or what? No. Pass over. Next.
Pass over. 16.
It's a real relief.
I was told I cannot come to court. I find it very difficult.
No, who told you? You cannot come.
That was what the circular.
No, we have issued a circular. He means Honorable Chief has issued a circular. On your request.
If you don't have VC, then you can come to court. Is how I for the circular.
Anyway,
I am very relieved personally. My lord, let me just explain what my position is. Then your lordship will decide whichever way. My lord, admittedly, I hire people and the service agreement itself says for this particular contract, your service is coterminous with that contract with the principal some company. They terminate their contract with me. Admittedly, it also says I can also use your services anywhere else. They terminate their contract with me. I, therefore, what has to be done is out of all of them, I find each one some alternate employment in my head office. Many of them. These people go and get an injunction against my terminating, saying you can't terminate me, although the contract says so. They get an injunction. Now, my lords, I say, all right, fair enough. I don't want to
transfer them.
I transfer them to my head office. I don't
Then
have
again an interim order.
Again an interim order.
Against which you went to the High Court.
High Court dismisses my writ. Now, what am I to do, my lord? I have no place to keep them.
It remains an interim order.
I don't have.
It remains an interim order.
Just 1 minute, my lord. I have no office in Pune. I have nothing there. I don't even have an office for them to come and sit. I can understand if I had an office, they can come sit in the office and do nothing. I don't have an office. My lord, my only work in Pune was for this particular employer. Now that man has terminated that. I'm saying, please come in Chennai. I have my head office. The contract, please see it. Allows me to transfer.
We'll decide. We'll direct the industrial court to decide the dispute or reference, whatever is pending, within 3 months.
Manoj, but then what they've done is they've now filed a contempt against me.
That will be stayed.
Please, my lord.
My lord, we have not paid from.
No, if they have no office in Pune.
No, my lord. Actually, they did not. The contract was terminated by them, not by the Kubota.
Where are you working? Where are you working?
Yes, my lord. We are working in Kubota, my lord.
No.
I'm not
Kubota.
That is
does Kubota has any work or contract?
Yes, my lord. Kubota is having work. He himself
at the place where you are
working. Yes, my lord.
Where is that?
Yes, my lord.
Show of the proof.
Yes, my lord.
Show of the proof.
Yes, my lord.
That Kubota
yes, my lord.
has some pending work
yes,
in Pune.
Yes, my lord.
In which case, let them go to Kubota. They've terminated my contract.
My lord,
they are not taking my people.
Your Honor,
either, my lord, he works with me. One thing I must say.
When we say Kubota means Kubota
is their principal.
Kubota has terminated
with petitioner.
Yes, my lord.
No, petitioners.
Anyway, we issue notice. Issue notice to the respondent. Full stop. Mr. So and so learned counsel appears and accepts notice. Full stop. The counter affidavit shall specifically file proof that the petitioner has any subsisting contract and work with Kubota in Pune.
Yes,
my lord. My lord, it can be clear from there later only.
You also filed
this file? Yes, it is filed on
full stop.
My lord,
post the matter on 15th July. 16th July.
My lord.
So miscellaneous week, post stop. In the meanwhile, contempt proceedings against the petitioner shall remain stayed.
My lord.
Yes.
My lord, the petitioner was recruited as a driver in the police force. My lord, there is a 3 judges judgment before of this honorable court, which deals with such situations due to difference of opinion between different benches of this honorable court. My lord, it has been held. He was having a matrimonial dispute with his wife. This judgment holds, my lord.
Matrimonial offense.
It was matrimonial.
One is 324.
324,
294, 506 and 279.
All related to matrimonial dispute.
Why did you not disclose this one?
In which he was
forget about matrimonial. We can understand matrimonial dispute. Nobody understands that it's a criminal case.
This other case was disposed of prior to.
No, you have to disclose it.
Prior to.
You have to disclose it. Our saying clearly applies.
My lord, we kindly see the judgment. It is held with that verification of antecedents.
This is Avatar Singh.
We found out.
This is what Avatar Singh says.
Yes, it has not been discussed at all. It has been referred to by the
No. It has been referred and relied. Not only referred, it is relied also.
Kindly see its paras 19 and 20. It was a reference
to a
larger bench.
That is against you.
It was a reference to a larger bench, as to what should happen in such cases. And it has been held that verification of antecedents is to find out fitness of the incumbent.
No.
These-
You see,
these don't get
verification is different. But when you conceal, that itself is an offense.
Even that situation is covered in this matter, my lord. And he's a driver, so it does not affect if he had a prior dispute with
Driver
the
did not disclose, according to you.
before. It is not going to affect
Sorry,
his fitness.
nothing.
My lord, may kindly see this.
Dismissed.
This judgment has not been applied. At
Dismissed.
Mr. Anpurkar is on BC.
Yes.
Notes. The only contention I'm placing before your lordships is that it is an admitted fact that an agreement to sell was executed between the parties. It is also an admitted fact that a portion of the consideration was paid. Now, once there is an agreement to sell between the parties, my lords, your lordships in Kanthi Mathi 2000 volume 9 have taken the view that the landlord-tenant relationship comes to an end.
No.
It is, your lordships will see that, and I leave it at that. Your lordships will only see that judgment for a moment.
Yes.
So 2000 volume 9 Supreme Court cases 339. We had given a
volume 9 SCC
339, my lords. And that refers to an earlier decision in Arjun Lal Bhatt Kothani that has been quoted. I'll read it from there, my lords.
You see, this first appellate court has referred to this Kanthi Mathi.
Yes, my lords, but with greatest respect, it has not considered it in the right
No,
context.
it has considered.
No, I'll tell your lordships. Firstly, may I show this judgment, sir, and then I'll answer your lordship's query right away. Please see paragraph 6 of this judgment, sir. Am I with your lordships at paragraph 6? May I read it?
Which paragraph?
Paragraph 6, sir. It is at internal page 341.
Yes.
Any jural relationship between two persons could be created through agreement and similarly would be changed through agreement subject to limitations under the law. Earlier, when the appellants were inducted into tenancy, it only means both agreed that their relationship was to be that of landlord and tenant. Later, when the landlord decided to sell this property to the tenant and the tenant agreed by entering into agreement, they by their positive act changed their relationship as purchaser and seller. When the seller landlord accepts the sum,
was the property delivered to you pursuant to agreement?
Yes, my lords. I was already in possession. Agreement has been executed. I
Forget about
continue to be in possession.
Forget about it. Your possession, as on the date of agreement, was that of a tenant.
Yes, my lords.
If possession is delivered to you as a prospective purchaser in that agreement,
yes, my lords.
Does it record that you have been delivered possession pursuant to this agreement to sell?
My lords, it does not say so in those many words.
Then your possession is still that of a tenant.
My lords, would your lordship just allow me to read a little further, perhaps?
Of a tenant.
My lords, would your lordship just
we'll deal with this.
May I just read a little further? Perhaps your lordship's query may be addressed.
As against the this agreed sum of rupees 1 crore, you will pay 10,000 advance, and you will say I cease to become a tenant.
No, may I just say this? My contention before your lordships is that once I have executed this agreement, the landlord-tenant relationship comes to an end. That does not mean, that certainly does not mean that I can continue to be in possession without performing my part of the contract. But here, my lords, since the suit
What is the date of that agreement?
My lords, that agreement is at page number 40, 21st September 2004. September 21, 2004.
Did you move any petition for specific performance?
No, I have not, my lords. I have not. But it is my contention that I have paid.
That forever now you cease to be a tenant, and you will neither file any suit for specific performance, and you will assert the property belonging to the landlord.
Can I answer this? At the same time, sorry.
We want an answer.
Yes. At this, the straight answer is that I have not filed any suit for specific performance.
Then you are out.
My lords, at the same time, the landlord has also not filed any suit for specific performance. Number one. Number two,
the landlord. Why should landlord will file a suit for specific performance? It is for you to file. You are the purchaser.
I understand that. So therefore, my possession may not be lawful in that sense. But the question which is falling for your lordship's consideration is that once the relationship has changed, does the tenancy court have the jurisdiction? In my submission, the tenancy court has heard.
And what I am saying, we are saying, observing, is precisely the reasoning in K.K. Sharma, which has been dealt with by the High Court.
Yes, but your lordships will just see that all the courts have disregarded this agreement on the basis that it's not a registered agreement. Now that certainly would be held against me, provided the respondent is disputing the agreement.
Why I especially asked you.
Yes.
Was delivery of possession happened at the time of execution of agreement? Because my next question would have been, if yes, whether the agreement was registered.
Lords,
because if there is
yes,
delivery
it's not
of
registered.
possession,
It's
then
not
it has
registered.
to be registered.
It's not registered, but for your lordship's first
then
query,
you are otherwise also out.
Lords, for your lordship's first
Could
query,
never have been delivered without registration.
Milords, for your lordship's first query as to whether I was put in possession pursuant to that agreement, your lordships may find an answer to the notice which was sent by the landlord at page 42, where he says that he put me in possession pursuant to that agreement.
Reserved for order.
Very. Would your lordships kindly permit me to? Would your lordships in that case permit me to submit a written note of argument?
Yes, please.
Grateful.
Petitioner is permitted to submit a written note within a week.
I will. Much obliged.
Power 42.
Please, Your Lordship. Your Lordship, this is against the criminal revision. Petitioner has been convicted under section 34(2) of the Petitioner has been convicted under section 34(2) of the MP Excise Act.
Surrender.
No, Your Lordship, he has not surrendered.
Surrender. Therefore, we are saying surrender. Please surrender.
Exemption.
Without surrender, you cannot maintain.
Yes, Your Lordship. Yes, Your Lordship, I will surrender. Exemption has been allowed by this honorable court.
Wrongly allowed.
Yes, Your Lordship.
Wrongly allowed. It should not have been. It should not have been allowed.
Your Lordship, 1 year has been.
You cannot be out. You cannot be out as an absconder, and yet you obtain exemption from surrender.
He has filed the criminal revision and therefore.
Sorry, dismiss.
His criminal revision was decided on.
Dismissed. Next.
Power 49.
49 minutes, I was led by Mr. Nikhil Goyal. I had taken the passover. Minutes, I was led by Mr. Nikhil Goyal. Minutes. I had taken the passover minutes last round, but he is still on his legs.
Any urgency?
Minutes can keep it next.
Post after partial working days. Yes.
66.
Wicket wala.
She's
wicket time on.
Yeah.
66.
Since
6
she's
months.
a widow,
6 months.
she was requesting for 1 year.
1 year is too much. 1 year is.
This is the only livelihood if possible. In 6 months, my lord.
You find out some reasonable.
6 months if possible.
6 months.
6 months.
66. No. On hearing learned counsel for the petitioner, we are not inclined to entertain this SLP. Accordingly, the SLP is dismissed. However, considering that the subject tenanted premises is a non-residential premises, we allow the petitioner to occupy the premises for a period of 6 months, for an additional period of 6 months. First of petitioner shall submit an undertaking before the registry of this court within 2 weeks that she shall hand over vacant possession of the premises to the landlord on or before 30th November. Yes, next.
Very good. Also 12. 12 है ना? ठीक है 12 क्यों 12 भी है वो दो बार फॉलो हो गया
Yes, 12. Well, none for the petitioner is in both the rounds. Post after partial voting. Huh? Very high thing.
My lords, I'm appearing in item 12.
Yes.
My lords, we would like to withdraw the petition, my lords.
Dismissed as withdrawn.
51. My lords.
Yes.
My lords, this is an after notice matter. My lords says on the last date that fixed the date for NMD, my lords. But matter this requires some time. My lords. Otherwise, I'm ready, my lords.
You post the matter on 8th September.
8th September. Interim continue, my lords.
Interim to continue.
Much obliged. I'm grateful.
52.
Please, your lordship. Senior is on VC. So senior is appearing.
For short accommodation for today.
Accommodation. How much?
Figure
As
after
paid by counsel for the respondent post after partial working day. 53.
Yes, ma'am. I pay for the responding.
Yes.
There is a request for a passover. We are being late by learning days.
Passover.
My lord, I am suffering because there is a stay that is being granted against me. I understand that, but he's on his legs, my lords. In fact, Lord, what happened was
We can't hear it finally now.
But no, it's a short issue. I'll tell your lordship what it is.
Huh?
Lord, in the High Court, the solicitor.
Yes.
Please do not. Lord, in this
Counter is filed.
Everything is fine. But in this case, in fact, there's a perjury. If I may, if my friend permits me,
yes.
There's a perjury because before the High Court, they took a stand as against me because I wanted my sanction documents. They took a stand that they are not giving them because these are third-party information. Here they come to this honorable court, make a statement in ground B that investigation is pending. In the trial court, they have filed a plea saying that investigation is over, and that is what they say in the trial court as well as the High Court in the collateral proceeding. The trial court in this proceeding itself. So they can't take contradictory steps and contrary findings are used.
Lord, in so far as the moot question is concerned, Lord, whether information can be granted or given only in respect of when the investigation pending or during the prosecution. Now, Lord, the prosecution was on, charge sheet was filed. This was specifically recorded by the single judge as well as the trial division bench, Lord. And in both the cases, Lord, High Court ignores H1H, wherein prosecution is when during pendency of the prosecution, it can be denied. In fact, my lord, thereafter, my lord, before the matter was taken up by the contempt court, my lord, we had already given them all the requisite documents which they had asked for, pertaining to and made in DOPT.
No, but this information is concerning the respondent himself.
Yes, but only myself, but I don't want for others.
It is not about third party.
There are third parties information. So, Milord, kindly see what is being sought for.
But if I may say, if my friend permits, they can redact the third party too. I only want it as against my sanction. I wanted not. And please note, my learned friend interpretation.
So far as this is,
allow me a moment. 818, Lord. My learned friend says information which would impede the process or apprehension or prosecution. Now, this will not impede the prosecution.
No, but
how will it impede?
The prosecution is pending.
Pending, Lord.
Why can't you make a prayer before
my
the
Lord,
trial court?
Can I tell your lordship, if I may just say this,
so that it is proved in court.
My lord, if I may say so. But today the issue is this. In my case, one authority said no sanction to be granted. There is an infirmity in that sanction could not have been granted, and they have CBI has gone ahead and taken sanctions. The CVC took a view. Now the issue here is when there is a fundamental CVC being the governing authority says no, not a case for sanction. Not I have a right to say the sanction is bad. The prosecution should fail. Before the High Court, they say they are willing to give documentation, but they say just a minute, sir. They say third party information. Now please see ground B before your lordships in the SLP at page number 75. Because this is slightly distinct. Not what is being argued here today. With respect, my friend is saying something else. Ground B at page number 75. They are saying
8 of my counter. Their counter.
My
Their counter. Now they themselves agree that there has been a compliance, partial compliance of the order. Now, my lord, before that, my lord, I would just like to take, my lord, to page 88 of my petition, my lord. Page 88, before my lord have a look at a counter, my lord, may kindly have page 88 of the petition.
What document is
88 of petition or
petition? Petition, first petition, my lord. Their RTI application, my lord.
Yes.
Now, what they have sought for?
Yes.
88, my lord, description of information sought. Copy of complete file. Copy of complete file noting comments, advice made in DOPT or issue of my prosecution sanction in the case of INX Media. And copy of complete file correspondence noted advice made in DOPT on issue of my prosecution sanction in the case of INX Media. Now made in DOPT is a importance. Now kindly have page 8 of their counter. We provided them the information after the division bench order, my lord. Where is that order? My lord, we kindly have page 8, my lord, of the counter. Page 8.
Page 8 counter.
Please.
Yes.
Now, my lord, we kindly have the third line. Petitioner had partially complied and wide letter covering letter dated 99/2025 had supplied documents to the respondent under his RTI application that also included order dated 26/8/2019 issue under the signature of Under Secretary to the Government of India, whereby the central government accorded sanction under Section 19 of the Prevention of Corruption Act 1988 and Section 197 of CRPC for prosecution of respondent after considering and taking into account underlying material, that is comments of administrative ministry, that is Department of Economic. Now this is all third party. Advice of CVC recommending section for prosecution of respondent, record of case submitted by the CBI. Now, my lord, insofar as when the prosecution is pending, now, my lord, we kindly come to page 104 of the petition.
My lord, may read the whole of the top part of para 9, lord, because it says, which my friend missed that, which underlying material was submitted to the competent authority, after which competent authority was.
So it was submitted to us, my lord.
Let me just read those 4 lines if you have not read it, sir. After sanction for prosecution under 90 and 19 was, but which underlying material has been withheld from the respondent till date on one pretext or the other, and the copy of the orders is at the cost of reputation, it submit the respondent is only seeking information with regard to sanction accorded for his prosecution. That's the point.
My lord, may kindly now have page 104, my lord, of the petition. Page 104 of the petition, my lord. Now, this is the order passed in appeal, my lord. Annexure P4, my lord. Order passed in appeal. Now, what the appeal? 104, my lord. While rejecting the appeal, my lord, in para 3, it was specifically held. And whereas it is found, my lord, Justice Mr. Gotter. 104. Please, para 3, my lord. Yes. And whereas it is found that the information sought for cannot be disclosed when the prosecution of the appellant is pending before the Honorable Court, as the award file contains vital details of investigation, gist of report, and documents related to Central Bureau of Investigation in case of prosecution. Further, the file also includes inputs of related investigation agency, including witnesses' account, evidences, disclosure of which may pose impediment to the prosecution. Now, my lord, may kindly see the impugned order, how it has been dealt with. This issue has been dealt with.
Good. But my learned friend may also show P7, which is the first single judge's order. Single judge in my favor, LP in my favor, and then contempt.
No, I'll show that also. Let me show that. Yeah, please, I'll show that.
Great.
As if P7, Millard. Yes. Now, Millard, kindly a page 142 of this. Para 5.
142.
142, Millard. Now, Millard, no word, no means prosecution is not mentioned in the whole judgment. Kindly a para 5, Millard. Careful reading of the provision reveals that the holder of information can only withhold the information if they are able to demonstrate that the information would impede the process of investigation, of apprehension, of prosecution of the offender. In the present case, undeniably the investigation is over and the charge sheet has been filed. Thus, in the opinion of court, respondent denial of information premised on 8(1)(h) of the Act cannot apply. 4 lines above, the Honorable Judge is recording that or prosecution of offenders, and 4 lines below saying 8(1)(h) of the Act cannot apply. Similar situation was considered by Union of India OPNR, wherein the court, after referring to several other case laws, have taken a view that 8(1)(h) of the Act would not apply in case of investigation as concluded.
Yes, Mr. Luthra.
Now, Lord, this is the single judge's order. Kindly just consider this matter. My learned friend should have read perhaps from page 2.
Impugned order.
Yes, no single judge. Not this is not the impugned order. Yes. It's the single judge's order. Now, kindly see.
Para 2.
Yes, not para 2, para 3, in fact, which will begin, Lord.
Page
which quotes the CIC order. Yes, not 139, Lord.
Yes.
In the second appeal, the central information impugned order is service. Now, not the order is quoted. Then please come to para 4 at 141. Counsel for petitioner states that his request for information pertains to his prosecution sanction only. The sole ground for denying the information by response, as is evident from the order of First Appellate Authority as well as C1 CIC, is premised on Section 8(1)(h) of the Right to Information Act, which reads as following. Now, I'm not kindly note H, information which would impede the process of investigation or apprehension of prosecution offenders. Careful reading of the provision reveals that the holder of information can only withhold information if they are able to demonstrate that the information would impede the process of investigation or apprehension or prosecution. In the present case, undeniably, investigation over, charge sheet filed. Thus, in the opinion, denial of information under 8(1)(h) cannot apply. So 8(1)(h) is dealt with. Now, Lord, please come to the single judge's order. Lord, please come. Now, Lord, please note. Para 6. The contention of respondents that Section 24 of the Act is applicable is not tenable.
Yeah, 1.
Para 6, Lord. Para 6. The contention of respondent that 24 is applicable is not tenable, as this argument was not presented at any stage either for the CPIO, nor during the appeal, nor even civilians. Now, Lord, please come to the impugned orders. Let's go one by one, Lord. Please see for a moment the first impugned. This should be the first impugned order. This is not the single judge's order, the LPA. Yes, but page 1. Please see, Lord, page 1. And if my Lord is kind enough to come to
page 1.
Page 1, Lord, is the order beginning. I want your Lordship to consider para number 4. Present letters patent appeal at page 2 has been filed by the appellant challenging the order dated 16th of August passed by this court in writ petition number so-and-so titled Probate Siksena, where the learned single judge had directed the appellants to furnish information to respond pertaining to response prosecution sanction the media within 2 weeks. Then, Lord, they are agreed. Now, the facts are noted from para 6, 7, etc.
Now please come straight away to para 9. Miss Divedi, learned CGSE appearing for the appellant at the outset submits that information is sought as respondently is clearly covered by the exemptions provided in 8.1, particularly clause H. She submits the information sought by response related to file noting, comments, advice appended and endorsed in the appellant by officers concerned in seeking complete file of the correspondence notings files appended and endorsed in the appellant department is ipso facto dependent upon the report received from CBI, which essentially contains sensitive investigations in regard to investigation carried out up to that period. An investigation is complete. She forcefully submits that disclosure of such information would entail within its scope disclosure of sensitive investigating reports are generated, which may include references to other persons or officers who were found to be involved in the offences noted in the RC. She submits that appellant would be in no position to provide information sought without compromising or either sensitive material indicating the involvement of the respondent and other officers or without disclosing the names and roles of other officers. Either way, information sought is intrinsically connected with the investigation conducted so far and would necessarily impede the
What is this INEX media case?
Not this is an INEX media case.
What is the case about?
Not it's a case where they say that the former Home Minister, Mr. Chidambaram Lord, had given favors to somebody. I was a joint secretary in the department, and there is, and if I may just point out, not that is the case. Now, here what is interesting is not in the trial court, the stand is taken that barring one letters rogatory which we are giving up, the investigation is open to letters rogatory which we are likely to give up. I want your lordship to see that. And here they're saying investigation is pending. Now please see further. And the stand taken, which your lordships were impressed by and gave a stay, was in ground B that investigation is pending, which is a false statement. Now please come further. Now, Lord, in para 11 again, 81H and 24 is argued. Then, Lord, please come to the findings of the learned honorable judge. Para 15, Lord, at page number 10. Having heard the learned counsel for the parties producing the records, examining the imputed judgment, the submission are made. Then, Lord, RTI's purpose is noted, your lordship judgment. Now, Lord, please come to para 19 straight away, page number.
We have not noted that investigation is pending.
Lord, that's the ground B. That the ground was never.
Ground, there are several grounds. In our order issuing notice, we have not said.
No, but that the ground that my friend is saying today was not taken in the SLP. The ground was investigation is pending, and I show that to your lordship. Your lordship is not noted, but that's the ground that was taken.
Yes.
Now, please come to 19. In the present case, undoubtedly the charge sheet was filed in the month of October, which is almost 6 years to date. It appears during this period that the respondent was released on bail as per submission. There is nothing to show on record that the investigation has reached any conclusion, may still be progressing. However, the appellant is not denied that charge sheet stands filed as far back as 2019 as noted. It would be apposite to examine the nature of information sought by the appellant. Now, Lord, please come further. I'm sorry, Lord, my learned friend wants me to point out three things, Lord. That's it. Lord, in para 18, my learned friend wants me to point out in para 14, last 4 lines. Apparently, the RTI Act appears to be providing transparency to disclosure to the extent possible, including but not limited by applying the doctrine of severability. Now, Lord, please come straight away to para number. Lord, para 20 quotes the single judge's findings. Now, please come to 21. From the arguments addressed by the parties, particularly the respondents, it is clear that the only information he speaks is in respect of sanction accorded by DOPT for his prosecution in the case of Annex and the file noting comments, correspondence, advice written by the appellant while granting sanction. There is nothing.
I didn't get what this apparently the RTI Act appears.
No, that was in 18. That was saying what is the purpose of the RTI Act? The court opined on that. That's all.
No, this observation is not correct.
The court says not doctrine of severability.
Yes, the doctrine of severability cannot be applied. Therefore, if the information contains the information seeker and together with several other persons, then since it can't be severable, information has to be supplied.
No.
That is what the learned judges are saying.
No.
That however sensitive it may be, if X seeks its own information, and together with it there are information of A, B, C, D, E, F, all have to be supplied because it can't be severe.
But may I just say?
That is absolutely perverse reasoning of the division bench.
May I just read it with you again, because if your lordship is perverse, not, I will clarify why it is, to say the least.
No, you see,
logical.
We are making it clear so that you argue and convince us.
Yes, of course.
That either the judge is, either High Court is wrong or we are wrong. Convince us.
No, Lord. Your lordship is never wrong, but I will try and assist your lordship to say why, to come to the correct conclusion.
Yes.
Now, Lord, apparently the RTI appears to be providing transparency, and not this will have to be read in the context of 18 in total. Then let's read it completely, not 18 in total. Let's read 18 in total. Section 8 carves out exemption from disclosure of information from clause A to J. 10 is in regard to severability, which can be exercised by the concerned CPIO in providing information to that part which does not contain any information which is exempt from disclosure. So this says you can sever what is not restricted and give that. That is what it says. And which can reasonably sever from any part that contains exempt information. Please read it in context. But that is what the court is saying. It appears that 10 is an enabling provision conferring discretion and a right upon the CPIO to grant access to such part of the record which does not contain exempted information under provisions of 8. Apparently, RTI appears to be providing transparency to disclosure to the extent possible, including but not limited by applying the doctrine of severity, that to sever what is to be exempt must not be given, what is not restricted can be given. That's the point, and therefore it is not perverse. It is absolutely in line with what the purpose is in terms of section 10, and that's the point I was making. Now 21. From the arguments addressed by the parties, particularly the respondent, it is clear that the only information he seeks is in respect of the sanction accorded by DOPT for his prosecution in the case of INX Media and the file notings, comments, correspondence, and advice rendered by the appellant while granting such sanction. There is nothing in the queries which point out to him seeking any sensitive materials or investigation which is already not part of the charge sheet. In fact, along with the charge sheet, the list of witnesses and their statements under 161 must have already been furnished to respondent according to the provision of CRPC, meaning thereby the role played by him and other persons, including other similarly situated officers, is also revealed to him through the charge sheet. All that the respondent now seeks is under RTIs in respect of file notice in regard to sanction for prosecution for respondent law. Another relevant issue, though not rising, is in respect to the law enunciated. That's on fair disclosure. I won't trouble your lordship with that. Now, please come to para 23, page 20.
Yes.
Ergo, we do not find any reason.
Yes, para 21.
Please come to para 23. Ergo, we do not find any reason to sustain the unfounded apprehension of the appellant that insistence that such information is exempt. Now, I'm going to pause here. 17th October 2019, the charge sheet is filed, document supplied. Thereafter, my lord, the matter, there is a supplementary charge sheet filed on 12th of May 2025. Thereafter, my lord, please note the date, 30th March 2026, they move an application before the court saying that all documents, everything is over, we don't require anything, barring 2 NRs from Bermuda, which we may give up. So that is the position, and that I filed that on record before your lordships. Now, please come to 24. And therefore, there is nothing in terms of those statements which have not already been given to me. But I just wanted the notice not. So that issue of statements, investigation, all of that is completely, I'm sorry to say, not in the air. We have also perused the judgment rendered by the learned single judge of this court in Nahar and Sudhir Ranjan. We dare say that both the judgments have been rendered in almost identical factual background. No judgment has been cited by the appellant in favor to contrary to the judgments of Nahar and Sudhir Ranjan Senapati. The relevant paragraphs of OP Nahar are extracted, and then not the relevant paragraph extracted. Now please come to paragraph 14 of that relevant paragraph at page 21 bottom. A careful reading of the provision would show that holder can only withhold information if it is able to demonstrate that the information would impede the process of investigation or apprehension or prosecution. In the present fact, as stated above, clearly demonstrate that investigation is over, charge sheet is filed as marked as 30th December 2010. Question then is, would the information sought for by respondent impede the respondent's apprehension or prosecution? Respondent in his report, he says he been granted bail by the competent court. Therefore, prima facie, the view of the competent court which is trying him is that there is no impediment in apprehending the respondent and that he would be available as when required by the court. Petitioner makes no averments as to how the information sought by the respondent would prevent his prosecution. In that view of the matter, according to me, provisions of 81H will not help the cause of petitioner. Accordingly, information as directed by CIC will have to be supplied. It is so ordered. In support of my proposition, I may only rely on, and then those judgments are referred to blood of the various. Now, para 25. In view of the above aforesaid analysis, also the reasoning rendered in OPNR, We do not find any reason, much less cogent reasons, to interfere with the impugned order. As a result, the present appeal is bereft of any merits and is dismissed herewith, however, without any orders to cause. Now, Lord, may I just draw your Lordship's attention to an IA 12311 of 2026. Kindly just come to annexure A3 of that.
Then I then
12311. Please, in fact, Lord, my Lord may just see that application. Sir, ये नहीं sir, ये 12311 होगी sir. Application under 379.
This we don't have.
Yes.
This we don't have.
Lord, my Lord may just see.
Not this application I don't have.
Sir, it's been served on you. Not, sir, it was served. Sir, it was served in the same day. You can't file it without serving to you. Now, Lord, kindly just note, services complete as per the office. What will I can give you?
What is this IA number?
Lord, 12311.
12311 of 26.
Yes,
Lord, I don't have this document.
Have it. Let us see.
We give a copy. We give a copy. So it's just a factual revision.
What are you pointing out?
Lord, I'm pointing out. Lord, just please come to para number. Lord, straight away to Lord annexure A3. Please. Annexure A3 is the stand in the trial court as on 30th of March. Lord, page 171.
171.
Yes, annexure A3. Does your Lordship have that? Lord, para 2 stand is they've completed investigation and further investigation was open. Thereafter, my Lord, please come to para number 3 at page 173.
No, that is not.
Lord,
that is not disputed that charge sheet is filed.
No, Lord, I want to show your Lordship something else, Lord, because the purpose they are saying is, Lord, they have to make out, Lord, I must tell your Lordship, today my learned friend is arguing a case that it will impede. He has to make a case out how it will impede. He can't just say investigation is pending, because his stand is investigation is pending, therefore it will impede. That is the stand taken in the SLP, which is, so today he takes a stand, he goes back to an earlier stand. Now please come, Lord, straight after to para number 3, that while order dated 21st October, the court was pleased to take cognizance. Present case is currently at the stage of framing of charge. 4. Subsequently thereto, a supplementary report under 173(8) was filed by CBI on 13th June and substantive offences added against 4 additional. Now, Lord, para 5 talks about certain letters rogatory. Para 6 is after receiving letters rogatory from UK, Singapore, Switzerland, same was scrutinized and application closing these LR requests were taken on record. Now, please come to Lord. And these don't relate to me, Lord. Para 7, they don't relate to me at all. Now, please come to para number 9. LR sent to both Bermuda and Mauritius in 2018 for observing details of accounts as to a certain of funds of so-and-so. Para 10. LR execution was sent to authority and this court was pleased to allow retention of the documents received in the form of competence for the purpose of investigation. Documents received were scrutinized, the details are as under. Then he gives all the documents, Lord. Now, please come to, and please note, all these details are given. Now, Lord, please note, para 12, that in view of the aforementioned fact, the documents received from Bermuda are herewith submitted to a list of documents for kind. In view of the above, it is therefore submitted this court may be pleased to accept documents received from Bermuda as additional documents and LR issued to Bermuda may be treated as closed. Now, this is their stand taken, Lord, in this matter that barring one LR, everything is closed. Now, I'm only asking regarding my sanction, Lord. I'm not asking for anything else. I'm not asking for investigation. Another status report in the High Court in a collateral proceeding, and please come to page number 54.
How are we concerned with all this?
No, but I'll show you.
With RTI.
But all I'm saying is what they say now, that even that is closed. At page 54, my lord may not open it. They say even that is closed. At page 54.
That is means the charge sheet is filed.
Not only charge sheet. The last LR, they say it may or may not come, we are not interested in it. Trial court can proceed. That's their argument. So they take the stand.
We are not concerned with what is happening in criminal court.
I tell you.
We are only dealing the RTI.
That's the point I'm making is, Lord, my learned friend will have to therefore, Lord, make out a submission, Lord, which, if I may say so, will have to be made out as to how 81H the proceedings are going to be impeded. That case, I'm sorry to say, Lord, it was not pleaded in the SLP. The only plea is 3-4. Failed to appreciate 81H PC, first ground, because Honorable Court failed to appreciate that 81H is not applicable. It's a typographical error. I won't go on that. Because the High Court failed to appreciate that investigation is not completed, wrong statement, and thereafter not OPNR. And then they said,
heard on counsel for the party reserved for judgment. Parties shall submit written submission.
I'm just
along with list of citation within 1 week.
I'm just giving my note. I'm giving my note.
I copy book. I'll take a week. They have a copy, sir.
Yes, next. Call the next case.
I appear for the respondent. When your lordship issued.
Yes.
When your lordship issued.
I appear for the petitioner, my lord.
What?
I appear for the petitioner's state, my lord.
When your lordship issued notice, my lord, kindly see the order on 25th March 2026. Your lordship had restricted the notice only to the extent of payment of back wages. As the tribunal has not awarded back wages, but the High Court has awarded wages. But kindly see what the High Court has taken note that tribunal has not awarded the back wages, and it was only under section 17B of the Industrial Dispute Act. The wages has been full wages has been paid. Kindly come to page number.
No, where is the order directing?
25th March 2026.
Where is the order of the trial court, the labor court, directing payment of back wages? You are appearing, Mr.
No,
my lord. I am for the petitioner state. I am for the state, my lord, under petitioner.
Yes.
My lord, my lord was pleased to issue notice, my lord. The respondent has appeared and filed counter.
No, counter is filed.
They have
we'll hear it finally after partial working days.
Obliged
on 18th August.
Obliged. Deeply.
Yes.
Obliged.
35.
Your Lordship, in this matter, good faith, I have joined. They have made a mockery of your Lord's order. Let me. I have given them a joining letter. My role and responsibility, no charge is handed over me, and I was made to sit like a boy waiting there like a 12th man. Total discrimination. In the later experience,
he's making a very false submission. Let me. Because on the last date, there was a specific direction to reinstate him as a cashier receptionist. We have done that. In that letter, we have mentioned that
later in spirit, your lordship's order to be followed by just to as I was not to come before this court.
It's completely a wrong submission.
Yes. Because my client is there in the BC, he can be verified, your lordship, for your satisfaction.
Even I can ask my client to make a video recording.
Not video recording. He's there. He's present before your lordship in the BC hearing.
Will you let me speak, The last direction.
It's a letter in spirit. It's a poor man.
He's making a very wrong submission.
Must you permit him to speak?
Then you speak. Very well. Very well,
So, and also back wages were not paid.
This property is this Hotel Sai International.
Yes. It's the number 1 hotel of the Rayagada district, this district headquarters.
Yes. And this, you are the owner of that property.
Yes.
I'm the managing director.
Company which owns the property, you are the owner effectively.
Yes. Now, Milord may have just, on 17th, it was e-filed on 16th.
We'll close your hotel.
Milord, kindly let me submit. What I have done, Milord, on Friday,
we'll close your hotel, I am telling you.
Milord, please,
don't understand.
This is the reason I was interrupting him, Milord. He's making a very wrong submission. Milord, for a moment, Milord, I had e-filed.
Whether you are allowing him the work of
yes, Milord.
Yes, or not.
Yes, Milord. Milord, on 15th, Milord had directed me to reinstate him as a cashier cum receptionist. Milord, on 16th, I e-filed.
Yes, what is your objection now?
My lord, I went to, they have not received the call. They have filed this, not given to me. They filed it on 16th. And when I called them, I am coming to give the joining report, they avoided the call. On 18th,
we'll monitor it for some time.
No, yes,
we'll
it,
not
keep,
close
keep
it.
it pending, your lordship. You keep it not.
My lord, may I have the joining letter?
The learned counsel for the
charge could be given.
Respondent submits that the petitioner has been allowed to join as cashier cum receptionist at Sai International.
Without charge being handed over to you.
Sai International Hotel. Which place?
Rayagada.
Rayagada.
Yes, ma'am.
And
Odisha.
From 20th.
From 20th May 20.
No, let it be clarified with effect from 15th, because the letter was issued from 15th.
With effect from 15th May 2026. Full stop. Let the petitioner be assigned the work of so and so, clerk cum receptionist, cashier cum receptionist in the subject hotel. Post the matter on 6th August.
Well, there are two submissions, my lord. Because they are keeping it for 6th August.
Back wages may be given to me.
My lord,
you must do the work. Yes.
My lord, there are two submissions. My lord, first is that my lords have already indicated that I have been reinstated. My lord, he has been reinstated as cashier cum receptionist. It may also be mentioned, and my lord may observe that with the same terms and condition wherein he was initially. We have mentioned it in the joining letter as well. Second, my lords, on the initial, prior to 2 days ago, my lords had granted me 6 months time to clear all the back wages. It was coming down to 6.5 lakh. We'll do that.
Not 6.5 lakhs. So this is something.
Whatever, we are not taking anything. That time is already running.
Yes, ma'am. He may not press the execution proceeding. He may not press. He will go then again press for the back.
The time which we have allowed is still going.
Yes. We have not.
Yes, next.
56.
I am appealing for respondent 1 to 3 in the matter. Not simply for me time to find my counter.
4 weeks for counters. Next.
Your Lordship, sir, permit me to take fresh steps for respondent number 4 and 5, Your Lordship.
Yes, sir. Petitioner is permitted to take fresh steps for service of notice to respondent number
4 and 5.
4 and 5. Yes. 52 letters adjourned.
57 letter. 58.
This is a transfer petition.
Transfer petition, yes.
Notice was issued the last time.
May please, Lord, I am appealing on behalf of respondent, my Lord, husband. So, Lordship, may consider my request for mediation.
Mediation. Yes, the parties are referred for mediation.
Before Supreme Court legal.
To be conducted by the Supreme Court Mediation Center, where they will appear on during vacation. Chalta hai kya mediation center?
So VC may be allowed during vacations.
No. During partial working days, the mediation center works or it ceases to work.
That we will take the instructions.
On 2nd June. So, where they shall appear virtually on 2nd June. Full stop. Thereafter, they shall appear either virtually or physically, जैसा लिखते हैं ना, so and so. And post on 15th September for submission of mediator's report.
I'm grateful to your Lordship.
Yes.
59.
59.
Yes, Mr. Raju.
I'd argued, but this is what I'd argued apart from the last occasion. This is what.
Yeah, what is this?
Summarize what I've argued, excepting the part where I've shown that there was the FIR.
We'll hear it after partial working days. It can't be concluded now. Friday, 1 a.m. already, 1 p.m. Post the matter. So this is your written submission.
No. What I'd argue, just to recap.
Oh, recap.
It's already parted.
You take it. You give it. Recap it on the next date.
I'll give another copy on the next day.
One. Yes. Take. Where is your? Nobody is here. No, your team is not here. Unless the entire team is here, we don't get charged.
Mr. Banerjee is there. Kalyan Banerjee is there.
Oh, Mr. Calcutta Banerjee, where are you?
I am here virtually. The Honorable Chief Justice of India has circulated under his direction that the Monday and Friday will be the virtual. That's the reason I am in virtual.
He has permitted physically also. Only for you it was changed, the circular.
Oh,
now you need to appear personally.
my lord, I did with great pleasure always to appear before your lordship.
What date is August or September? Mr.
August August.
August. Let us try in August, 18th August. 18th is Tuesday. Yes, with the consent of for the parties, post on 18th August. Next.
Grateful, my lords. Grateful.
Lord, today I am missing the real interaction between your lordships.
Yes, we are also missing.
Miss physically, I am not there. I enjoy always.
Kalyan Bandyopadhyay appearing physically is different.
From virtually.
Yes.
Yes.
My lord.
Yes.
Yes, next.
Physically, there's more weight.
Yes.
Physically, when it appears, there's more weight.
There is always more weight.
I'm not commenting on that.
Yes.
I'm grateful, my lords.
Next. 60 letter.
61 will have to be 61 and 61.1. I appear in 61. 61, my lord, the survey, the pleadings are complete. The matter will require about half an hour's time.
Lord, anyway, then
Pleadings is
what is some regularization or what?
no, it's regarding seniority, my lord, of assistance, my lord, of the
There is
university.
already an order for non-miscellaneous day on 10th of October.
Yes. The only thing is, my lord, I beg to say, my lord, that 61.1. Apparently, the pleadings are not complete. There is no reason, my lord, they are separate judgments. There is no reason, my lord, why they should be tagged.
Post the matter on 18th August.
Very good.
18th नहीं करना.
Your lordships like
on 2nd September.
Yes, second.
On
Lord, can
अभी 18th को देखा ना वो पहले वाला. Post the matter on it's 1st September. Tuesday is 1st September.
Yes.
1st September.
Pleadings are not completed. Let it be completed. So.
Full stop. The parties shall complete the pleadings in 61.1 का
61
the number लिख देना 61.1 before the next date of hearing.
Right.
Full stop. The parties shall also be ready with list of dates, synopsis, written synopsis, and list of citations. List of citations along with copies.
Very good.
Yes.
Great. Lordships are listing it on an NMD.
Yes, it is an NMD.
Very
1st September is an NMD.
Very great.
Yes.
62. We took you for the respondents.
May it please your lordship. Your lordship, this is the matter where the ACRs were not communicated, lordship.
You are again elected something, I have seen. Secretary. Oh, congratulations. Yes.
Lordship, this is a matter in which the petitioner is a teacher, lordship, was a teacher and in Kendriya Vidyalaya, and he was not communicated his ACR, and the ACR was communicated after 12 years, lordship. That too after several representations, lordship. And even after the completion of the departmental promotional committee, lordship, things. And we have challenged that, lordship. And what the High Court has done is, lordship, the High Court has said that they have considered before the administrative tribunal, this was considered and has dismissed my petition, lordship. Lordship, I just wanted to take you through certain dates, lordship.
No, we are not hearing it today.
Okay, lordship. Then
because this is to be heard finally. Pleadings are complete and this is coming before us for the first time.
Yes.
It was earlier posted before some other combination.
Some other combination.
Lordship, I give a short date, lordship, in July.
You have lost before the tribunal and the High Court both.
Lordship, but that lordship.
Denying selection date to you.
Lordship. But lordship, I will just narrate a few dates, lordship, and
anyway, we'll fix it in on an NMD.
It is covered by a
post the matter on 25th August.
25th August.
Yes, Tuesday.
Lordship, I'll just bring on record one documented petition where I've taken these grounds specifically.
Petitioner is permitted to file additional material.
Lordship.
Yes.
Grateful, lordship.
Please.
Please.
Yes.
This matter, notice. I'm for the respondent number 1 and 4.
1 and 4.
Yes, 2 and 3 have died.
This is for enhancement?
Yes.
No, this is insurance company.
Insurance company is there.
Your Lordship, we have filed the petition. Your
On what ground you are challenging?
Your Lordship, I'm challenging because the vehicle was not involved in the accident at all, Your Lordship. And Your Lordship, this was, they had.
But both reports have found that it is not involved.
Your Lordship, the MAC.
The tribunal as well as High Court both concurrent finding.
MACT had, Your Lordship, dismissed their claim petition on this ground only.
The MACT had dismissed.
Yes, and then Your Lordship, they filed an appeal before the Honorable High Court. And
any
they have set
possibility
aside,
of compromise?
we haven't.
Samadhan tomorrow.
They have filed an execution petition, Your Lordship. And Your Lordship, in fact, warrants of arrest have been issued against us. Your Lordship, we have deposited the money on the condition of non-release.
Make an effort before the
non-release. Your Lordship, at least grant me stay because Your Lordship.
We have already deposited.
Yes, we have deposited on the ground of non-release, Your Lordship, but they have not.
We will pass an interim order.
You may stay the.
You see, we'll pass an interim order only till Samadhan Samadhan. The parties are referred to Supreme Court, Legal Services Committee for mediation for possible settlement in Samadhan Samaroh to be organized in Samadhan Samaroh to be held in Supreme Court on 21st, 22nd and 23rd August. The apparent insurance company has already deposited the award amount before the claim tribunal.
And an application has been filed for release.
Let the amount remain deposited, however, it shall not be released in favor of respondent till the mediation and settlement in Samadhan Samaroh is pending. Full stop. Pending. Full stop. Post the matter. Depending upon the outcome of mediation and settlement during Samadhan Samaroh, the matter be posted before the matter be posted on August, on 2nd September. So that the interim order remains effective till 2nd September. If it doesn't materialize, we'll hear it on 2nd.
Please, Your Lordship, there's no stay, Your Lordship. They should not press any coercive steps, Your Lordship, because they were almost going to issue warrants of arrest.
We have issued.
Yes, Your Lordship.
Granted a stay.
It is fine. Yes,
when we have granted a stay,
please, Your Lordship.
it should not be released.
Please, Your Lordship.
Which court will send you to jail?
We shall not pursue Malos.
Yes.
Obliged, Your Lordship.
Malos, only one thing. Malos.
Yes, yes.
Malos, she is widow lady of 72 years of age, Malos. Number 1.
Therefore, we have kept it for a limited period. The interim order is only for a limited period.
She has lost her husband, both sons, and Malos now no accident of 2004, and Malos very pitiable situation.
Even otherwise, we'll post it for hearing. If it doesn't go to Samadhan Samaroh,
yes,
we'll post it for hearing sometimes in July. And there is hardly 1 month between July and August. That is why we are saying, let us make an effort.
Let only these things.
Let us make an effort.
And what efforts they will make, they will say that order of the tribunal is good. I will say that order of the High Court is good. Then only to be decided on.
And we have to choose which one is better.
Yes, ma'am.
Yes. Next.
Meanwhile, Lordship, I may be permitted to file my rejoinder to respondent number 1 and 4.
Yes. Meanwhile, petitioner
may I put my appearances, ma'am? May I put my
take physical appearance? Yes.
Grateful, ma'am.
Obliged, Your
Much obliged.
Let's 64 for
Lordship, I am seeking short accommodation on behalf of respondent number 3.
as paid by land counsel for the respondent post after partial working days.
65. Pleadings are complete minutes.
Yes.
We had filed our counter, they had filed their rejoinder.
This matter pertaining to seniority.
Now this is to be heard finally.
Yes.
Some NMD.
NMD.
What is the matter? Any urgency?
No, Millets. It's regarding the seniority, seniority between
Staff
nurses of JIPMER.
They're not a serious issue.
According to us, we are
Neither urgent nor serious.
Because all of them are now working as nursing sister. It's only a dispute of seniority interest.
On, we'll hear it on say 11th August. 11th August.
67. Wait, please, Lord.
Yes.
Victim 67, I appear for the state. I filed my counter. The only urgency I may indicate, I realize this has to be heard. Just to give a, this is 200 acres of land which the state government granted by a lease to the petitioner society for cultivation. They don't cultivate it, they buy they build farmhouses, brick kilns, every commercial activity. There are concurrent findings again.
If I recollect,
yes.
Part of it and part of it,
So
the same issue, no?
Yes, Lord. So in the counter, we have explained now there is a DP reservation on the entire 210 acres. Various public projects are held up.
You said it on that day.
Millet.
And we wanted you to be specific.
We have filed that
projects you want to create in this.
Yes, Lord. We have filed our counter. We have explained the entire 210 acres. The problem today we are facing, Lord, as the state, is that all these projects are held up because, Lord, there is a status quo order which your lordships have passed. So lordships may just
let it continue for some time.
Only one real urgency. Other projects can wait. One real urgency of which on instructions. There are 5 regional medical hubs, which are state-of-the-art hubs, which are envisaged by the central government in 5 parts of the country. One of them, is at Ambernath. And that whole planning and construction and everything is held up. That's all I want to say. May consider modifying that status quo order.
But you don't have any part of this land in.
We are in
possession. Medical hub.
We are in possession.
Then status quo orders then.
Oh,
but because
you are in possession.
We are in possession.
But because of a status quo, you are not able to construct it.
Yes, that's the problem.
And what is the area?
210 acres.
What is the area in which this medical hub will come up?
Yes, similar to see page 18 of my counter.
Just say area.
Millard, I am told it is on the entire land because all ancillary for staff, quarters, residential
will continue.
Quarters, everything.
If it is on entire, then
we have explained that in our affidavit. Because houses, staff quarters, everything.
I recollect there was an earlier order.
Yes, Millard.
Forfeiting part of it, not the entire.
Millard only 19 acres. Millard only 19 acres.
Whatever.
Only 19 acres.
Whatever.
194 acres was resumed.
Wait for some time. You have filed rejoinder also?
Yes. And I've also pointed out one thing.
Reading, yes.
In my rejoinder.
Yes.
That this so-called urgency to acquire this 50 acres. It has only started after Mallards the SLP was lodged.
It always happens.
Issued notice.
Yes.
Which Mallards I've dealt with in my rejoinder. I've said it's mala fide because they've just tried to put it in reserve to show.
Every litigant has a right to impress the court.
Millard, I don't agree that this is mala fide. Millard,
one second, sir.
We are not accepting
lavish farmhouses, Millard.
Like
those photographs.
Like you have done your duty, Mr. Ahmadi is doing his duty.
Millard, alleging mala fides against public projects.
No.
Yes.
It is writ large on the face.
The pleadings are complete. Post the matter for consideration on 12th August. Wednesday, 12th August. Physical appearance. Physical appearance.
Yes.
Which matter?
41.
41.
Yes.
Yes, mediation failed.
Well, yes, ma'am. That's failed, ma'am.
Go to regular bench. You are appearing.
Yes, I am appealing for the respondent.
Lordship, I am appearing for the petitioner.
Process of mediation has failed. The other side, the respondent is appearing to you, learned senior advocate.
No, madam.
Mr. Learned counsel, Mr.
Yunus Malik.
So and so, so and so. Formal notice is issued.
Yes, ma'am. Pleadings are complete, madam.
Let the petition be posted before the regular.
Obliged.
Lordship.
That is not complete on R2.
Issue notice. R2.
You had already issued notice, so this can be complete नहीं है R2.
By the we receive regular after 4 weeks.
Wait, please, Your Lordship. Your Lord, it's a transfer petition by Y.
Service
We have filed the that's right, 1602.
Service is complete.
Service is complete.
We have filed the
counter affidavit. Now, my lord, the issue is, I got married 29 years ago.
Then now it will go to regular bench.
Yes, very well. So I may be given 2 weeks time to file the joint.
Service is complete. On both the sides are appearing. You will learn it to respective learned counsel. We did listed before the regular bench after 4 weeks.
Please, my lord. Lordships are listing it before regular bench after 4 weeks. Kindly grant me time to file rejoinder to his counter.
4 weeks.
Very well. I am so grateful. Grateful. Deeply obliged.
Pass it over.
Pass over.
Please, my lords. My lords, the service has been complete in this matter. The prayer is for transfer of the case from Family Court Udaipur to Family Court Bathinda, my lords.
Service is complete.
Please, my lords.
This is 1603.
1604, my lords.
Please pass over.
Please pass. So none appears for the respondent. The service is complete. The petition shall be posted before the regular bench. After 4 weeks.
Grateful, my lord.
Service is complete. I think we'll pass same on.
Please, my lords, the mediation has failed, my lords.
In
1606.
It was stated that the mediation process has failed. In that way, the petition may be listed before the regular bench after 4 weeks. Yes.
I am obliged.
Your Lordship, the service is complete on the sole respondent, but nobody has entered into appearance. The prayer is to
regular bench. Service is complete, full stop. In that view, the petition shall be listed of the regular within after 4 weeks.
much obliged, Your Lordship.
Service is not complete. Await the service on the respondent. Full stop. The petition will be listed after 6 weeks.
1609.
Lord, I am appearing for the respondent, Lord.
Fresh,
I will-
fresh. No, it is not fresh. It is a fresh method. No, sir. Service complete. So service complete, same. Petition service complete, full stop. Petitions will be listed with the
I appear for the petitioner, Your Lordship.
So it will go before regular.
1610.
I am for the respondent. I'm seeking some time to file my report.
Same order.
Lordship, I am appearing on behalf of petitioner in this matter.
Yes, service complete, full stop.
1611.
Partying person. Pass it. Yes.
1612.
Please, Lord, the service is complete. Already one case has been transferred from Faridabad court to Delhi.
Complete, it will be listed before the regular bench after 4 weeks.
Lord, in the meanwhile, because of the guardianship case filed, the child visitation is happening in Delhi.
They filed that, let it be stayed, not till that time. She's being, the court is proceeding. Well, already one transfer petition was allowed.
Maybe. Yes. Already, same order. Service complete.
Milord,
Yes. Who appears?
1613 is a service completed, Milord.
Yes, same order. We go before regular bench after 4 days. Same order.
4 weeks time to file counter affidavit.
It will be filed within 4 weeks. By the time it is listed. Yeah.
Hey, Lordship, the service is complete, but the respondent has not entered appearance.
Same order. We'll go before. What is that 161?
Please, my lordship, on the last date, my lordship had asked us that we can serve through the advocate, but it had not come on the order, so we could not get the summons from the registry. So I will request.
We shall wait. Shall we wait?
My lordship, the address is the same which has been provided by the respondent himself in the Section 9 petition. So I'm requesting 29. The matter is there in Bharatpur. I'll serve it through the advocate. So my lordship, allow me dusty service through the advocate.
As requested by learned counsel, Mr. So-and-so appearing to video conferencing, since the service by regular mode is not complete, he requested, as per request the service is permitted to learned counsel who appears to the respondent in the trial court. For this purpose, the registrar shall issue press notice. Full stop, thus the service is permitted. Notice shall be returnable after 6 weeks.
Much obliged.
Yes.
1 6 month payment.
Your Lordship, I am appearing for the petitioner wife in this matter. Your Lordship, the present transfer petition is filed by the petitioner wife. My Lord, sir.
So, correct matter?
Yes, my Lord.
Same order. You will got the order. Issue notice and say. Passport keep it afterwards.
Please, Your Lordship. For 1 second.
Let's put 1701 exemption for surrendering. May please submit an appeal under the.
How come that you have not undergone the sentence at all?
May please submit, Manoj. The High Court has protected. Kindly come to page 33, Manoj. That will give you an answer to the question also, Manoj. 33. Not every accused, Manoj. Only 2 people who are before the honorable court. Page 33, Manoj. 32 last time and 33 first line, Manoj. This court directs a substantive sentence imposed on respondent number 3 and 4 shall remain suspended to enable them to prefer an appeal. So there is no sentence as on is legally speaking. So the matter has to be heard on merit. Till then they may be exempted.
The applicant is granted exemption from surrender. However, only till the next date of hearing. Full stop. The applicant is convicted under section 302 IPC and sentenced to life imprisonment. Full stop. The registry is directed to list the SLP of the applicant before the regular bench on 26th May.
May place your lordship. May place your lordship in the same one. 1701.1. I would like to make a submission.
1 point.
It is for the accused Sarah Vinan.
There is no 1.1701.1.
However, it is a connected matter. I just wanted to mention it because it is a very serious matter. The accused is in jail in this matter, Sarah Vinan.
Not listed, madam. What can we do?
It is listed along with it.
1702, 1702.
01.1.
Let it be called.
1701.12. 1701.1.
It is not listed.
Listed, sir, but it is not in gist.
What is there? Where is the?
I have a paper book. I'll
Where is
read.
the paper book?
17.1.
I think I have the paper book with me. Read it.
So it is not in the list. Madam, it is not in the list. Nor the paper book is available.
I have the paper book. May I submit this?
How can it? How an order can be passed and not be listed?
It is
Get it listed to the registry. Go to the registry and request the concern.
Yes,
officer.
just making a small submission if it may be permitted, Your Honor. Since the accused is in jail, I just wanted to, because it's a connected matter, everything is related to in the same.
You can make whatever submission you want to make. I can't do anything without papers being listed, matter
Okay.
being
It
listed.
was there in the list, that is why.
Not in the list.
Not in the.
Also, the court master confirms that.
It is in the cost list, it was mentioned as 1701.1.
Paper book is there. You write in the order which passed in 1701. Which is that IA which you are mentioning?
It is criminal appeal connected with it.
Better you go before the registrar and get it listed immediately.
It can be listed along with the connected.
It will be listed. Why not?
It is not.
See that it is listed.
1701.12531 of 2026 is the diary number.
Must be paper book. How do I know that what is the? You can usually write, but without paper book, how can I know that what is?
Yes, understood. Your Lordship,
Take help of the court master and get it listed.
yes, with attached along with the main matter.
We'll do that.
So all good. Yes, on the next listing day, 26th. Much obliged. 1702.
Wait, acquitted by the learned trial court on the basis there is no evidence against me. The Honorable High Court overturns that on very specious two issues, one recovery and the other.
The applicant is granted exemption from surrendering till the date when his SLP is listed with the regular bench. Most of the SLP shall be listed within 4 weeks.
As in July, if I'm otherwise
Not
4 weeks.
immediately on the reopening.
I'm okay.
I'm 1702.1. But I'm in 170.
Same order. 1702.1. Same order.
I'm most of
My lords, in this case, the co-accused was also granted my lord the exemption for conduct.
Same order.
2-4 months.
Same.
Yes. Obliged, my lord. Yes. My lord, can it be listed next week, my lord?
Immediately after partial.
Obliged.
1004, my lord. High Court is acquitted all the offence under LPC, my lord. Only convict be under section the.
You pass the same order exemption.
My lord?
You want exemption?
Yes.
Same order.
Grateful.
1705.
Exemption.
1705 is also an exemption.
Write down. The applicant is granted exemption surrendering till the date when his SLP is listed to the regular bench. To stop, the SLP shall be listed within 4 weeks. See, not 4 weeks. Immediately after the partial working. Immediately after the partial working. Don't write in your language. Okay.
Well, 1705.
5 years.
Yes, well, that's also an exemption. The punishment is of 3 years.
Same order.
All right. Grateful.
It is also. Who is there?
Malas, this is also exemption.
Same order. Same order.
So obliged.
Deletion. Who is there?
I'm here. Your Lordship, I appear in this matter.
Yes.
Filed an application for deletion of respondent number 1 and 2. This is an MACT, SLP against an MACT order. So, respondent number 1 and 2 are the owner and driver of the offending vehicle.
Learned counsel, Mr. So and so, agreeing to video conferencing. Raise to delete. Respondent 1 and 2. Who are the owner and driver?
Yes.
Motor accident claim proceedings. Stating further that they are not necessary parties. Stop. The prayer is granted. The said respondent 1 and 2 shall stand deleted from the area of the respondents. However, at the cost, risk and consequences of the applicant, IA number 120250 is allowed.
Grateful.
1708.
Yeah. Yes. These are the applications. for restoration of the main petition as well as for condonation of delay in filing the restoration application.
Yes, Your Lordship, I am appearing for the petitioner.
In regard to the paragraph, amendments made in the IN
66 हो गया
Defects has been duly cured in this.
having regard to listen to having regard to the amendments made in the application for delay condonation, sufficient cause is made out. Therefore, delay of 60 days is condoned. As far as the prayer for restoration is concerned, in order to enable the applicant to contest his case on merits, restoration is permitted. We made diary number 5011 of 2025 in SC D number 4112 of 25 shall stand restored to its original type. Of the applications, IN number 145974 and 45973 allowed.
Oblige, Your Lordship.
1709.
Yes. What is that? Nobody is there.
Lordship online, he is appearing online.
Yes, Mr. You are muted yourself. 09. You muted yourself. Unmute yourself.
Please, my lords, I'm sorry. My lord, there is an application for deletion of 4 respondents. That is IN number 6271 of 26. And second is, my lord, I may be permitted to serve on respondent number 1 through Dusty service. But the third issue is respondent number 4 filed the counter against which I may be permitted to file rejoinder.
Prayer in the present IN is to delete the names of the respondent number 5, 6, 8, and 9 from the area of the parties. In specially petition serial number 38299/2025. On the ground that they are not necessary parties for the effective adjudication of the controversy involved in the matter. Anyway, what is pleaded paragraph in the application, the prayer is granted. The said respondents number 5, 6, 8, 9 shall stand deleted from the area of the parties at the cost, risk, and consequence of the applicant. Application is accordingly allowed. What else?
But I may be permitted to serve respondent number 1 through the
paragraph. This one is concerned from the counsel, learned counsel with the petition is permitted to serve the said respondent through the service.
My lords, one thing more, my lord, I may be permitted to file rejoinder to the counter of the respondent number.
Nobody prevents you. Yes.
I'm highly obliged, Mr. President.
1710.
Lordship, filed this application for restoration. Initially, we have filed civil appeal, my lord. Then the registry read an objection, SLP lies and 50,000 rupees as the court fee.
No.
So some time was lost, my lord.
This is for restoration and for condonation.
Yes, ma'am. Yes, ma'am.
So you same order will be able to pass. In the earlier it was a delay of 60 days. Instead of 60, 140. Yes.
So, 2 days delay in refiling.
Delay of 2 days.
2 days.
In refiling the matter is condoned. Accordingly, IN number 128697 of 2026 is allowed.
Request for listing before court, my lord. Request for listing before court.
The main SLP may be listed before
court
bench immediately after the partial working days.
It's an original suit, not SLP, my lord. It's an original suit.
Original suit.
Oh, obliged.
Item 171.
Original suit, diary number 18083 of 2026. Yes.
1796.1. Yes,
What is the delay? But you not indicated delay.
My lords, they are poor villagers. They are villagers, so therefore there is.
Correct. So what is the extent of delay?
Yes, my lords. My lords, there are 4 applications.
Yes.
For 4 substitutions.
Yes.
IA number 91968, my lords. There is a. I will just my lords with the delay. My lords, in IA number 91968, there is a delay of 976 days.
976. Yes.
Yes, my lords. In IA number 91973, there is a delay of 1422 days. 1422.
1422.
Yes, my lords. My lords, in IA number 91976, there is a delay of 1285 days.
Wait.
Yes, my lords. And my lords, in IA number 91979, there is a delay of 2946 days.
No, in 91996, what is the delay?
91976, 1285.
1285. That is in 76.
In 76, my lords.
And 79?
292946.
So 68 is 976, correct?
Yes, my lords.
Just repeat for my part.
Yes, certainly, my lords. Certainly. My lords, in 91968, it is 976 days.
Correct.
In 91973, it is 1422 days.
Correct.
In IA number.
Yes, all are allowed. I'll pass you.
I'm so grateful, ma'am.
Send to me. Send to the home office. Send the file to home office. Yes, next.
My lords, I am appearing for the petitioner in 7.1.2, my lords. There is substitution application, my lords. IA number 88047, my lords. 1712.2, my lords.
1712.2.
Yes, my lords.
Substitution.
There is one substitution application, my lords. IA number 88047, my lords. The deceased has been expired, my lords, on 3rd of January 2026, my lords.
There is no delay.
No, my lords.
So allowed.
Grateful, my lords.
So send to my office. Yes, next.
Oh, I am appealing for petitioner, my lord. This is the criminal appeal. The petitioner already died. Death certificate already filed, my lord. The name of the petitioner name in criminal appeal is Deivam alias Deivendran. In death certificate shows K Deivam only.
So you
For
file,
that,
you file some additional proof to.
yes, I have filed wife affidavit. She is she is stating that both the names are indicating her husband only.
But it's already filed or going to file?
But already filed in office report. It is indicated. 12th May I have filed affidavit.
It is
Petitioner.
the name of the petitioner. As stated in death certificate. And one stated in the appeal. One stated in the title of the appeal. Differs. Full stop. Paragraph. In this regard, counsel Mr. So appearing to video conferencing stated before the court that he has filed an affidavit of the wife of the deceased who confirms that both the names mentioned in the death certificate as well as in the appeal memo are of his husband and that he is the same person. Paragraph. The officer, the registry shall examine the same and do the need. Next.
Much obliged.
Yes, who is that?
1714.
17. Yes, ma'am.
114 kindly allow service on fresh address received from Superintendent of Police. Lordship.
It was stated by learned counsel, Ms. So-and-so, agreeing to video conference that she will supply press address to the registry, which is received from the Superintendent of Police. Full stop. Upon the counsel,
I will be appreciative of service.
upon the learned counsel supplying the press address to the registry, the registry shall issue press notice to respondent 5, returnable after 6 weeks.
Much obliged.
Yes.
Yes. The advocate for the respondent is already appearing. We have served the copy, madam. So I think there is some delay in service, madam. It is a fresh matter. We have already provided the copy.
It was stated by learned counsel, Mr.
Name is also appearing over there.
Appearing
for the petitioner.
for the applicant that the copy of the petition is already served on the counsel for the caveator, and the learned counsel has also been appearing in that way. No further orders are required.
Obliged. Deeply obliged.
No, please, my lords. Deletion application has been moved for 7 to 11, my lords.
What
5 and 6 have died, my lords. There's no LRs. I've moved an application for that effect also, my lords.
6, 7, who is that?
Those 5 and 6, respondent number 5 and 6 have died, my lords.
What about 7? This is for 7 to 11.
7 to 11, we have moved a deletion because they have not appeared throughout the proceedings, my lords. They're non-performer parties.
Learned counsel, Mr. So-and-so, stating that respondent 7 to 11 are pro forma parties, not necessary as parties to be detained, not necessary to be detained as parties in the proceedings, raised for deletion of their names from the array of the respondents. The said respondents number 7 to 11 are permitted to be deleted from the area of the respondents, however, at the cost, risk, and consequences of the applicant. What about 5 and 6?
5 and 6 have died. There's no LRs, my lords, for them. That is also, there's another application we have moved, my lords.
You filed some note about that's stating that there are no LRs.
Well, we have filed an IA.
As regards respondent 5 and 6 who are dead, it was stated by learned counsel that there are no heirs and legal representatives. Learned counsel shall file necessary note before the registry stating that there are no heirs and legal representatives of the deceased. Respondent 5 and 6, therefore no further steps are required. File some note.
Please. Obliged.
Pass it.
Thus, I had filed an application to serve respondent number 5 to 7 by way of newspaper publication. On the last occasion, my lords, your lordship had asked me if the newspapers that I have mentioned in the application fall within the. Is there any list of approved newspapers, and whether the newspaper I have mentioned in my application falls within that list? I checked with the registry, my lords. They said that per se there's no list, but the newspaper.
No, sir, there is no circulation in the area where the.
Yes, but what the registry told me, my lords, that there are 2 newspapers that I've mentioned. One is the Telugu language, local language newspaper, and the other is the English one. So they said that the local language one is fine, but the English language I mentioned, capital information, that they said that you should publish it in a widely recognized paper like Times of India or Hindustan Times or something. So, Malas, I'm seeking for your lordship's permission, Malas. I'll file a fresh application to serve the respondent number 5 to 7 by way of
permission to file fresh application for paper publication.
Please.
Such an application will be filed within
2 weeks.
2 weeks.
I'm okay.
1719.
Wait, please, Your Honor. So I'll need some time to file substitution application for respondent number 5. And my instructions are that some other respondents have also died. So I need to find the whereabouts and the legal heirs and file an application for substitution for them as well.
As requested by learned counsel, Mr. So-and-so, 4 weeks time is granted to file the application for substitution, to bring on record the heirs and legal representative of deceased respondent 5. Full stop. It was further stated, paragraph. I learned counsel that other respondents, they also have died.
Yes, please.
Full stop. Full stop. With regard to those respondents, necessary steps shall be taken
Within 4 weeks.
within 4 weeks.
That's what I- Doctor, there is also an application for deletion. Two of the respondents.
17 and 27.
Yes. This is IA number 71501 of 2026.
17 and 27.
17 and 27, your Lordship.
Why do you want to delete?
They were actually proceeded ex parte before the trial court. And there were several other defendants who were proceeded ex parte, but they have been served.
Ordered in IA 71501/26. In view of what is stated in the application, from a prayer for deletion of this one 17 and 27 is granted.
Yes, ma'am.
Paragraph. These 8 respondents, 17 and 27, shall be deleted from the area of the respondents. However, it posts risk and consequence of the
That's fine. That's fine.
application is accordingly allowed.
Much obliged.
My lords, humbly seeking delay may be condoned, my lords.
Which one?
Service through standing counsel may be permitted, my lords.
45 days delay in filing
37 days delay, my lords.
is come down. Accordingly, IA number 154567 of 2026 stands allowed.
Service through standing counsel may be permitted, my lords.
But notice is already issued. Let us wait. It might come.
Yes, my lords. Yes.
Yes, next.
Much obliged.
1721.
My lord, I seek 4 weeks time to do the needful in this. My lord, the alternative address has to be.
Government Council, Mr. Francis, is 4 weeks time to take steps regarding unsolved sole response.
Sole response.
4 weeks time is granted as paid.
Deeply.
My lord, respondent number 6 has not been served. The envelope has been returned with marks no such person at the address. We may be permitted to serve through the district court.
But how will you serve when there is no address? No such person in the address.
Yes, my lord. So
Some alternative substituted service. Go for that.
sorry.
Go for substituted service.
All right, my lord. My lord, we can also serve it through the local police station.
No. What is substituted service? Do you know? Under what provision of CPC?
Yes, my lord. Through the local newspaper.
Which is the provision?
My lord, I apologize. I don't remember the provision.
You must declare it to Supreme Court. Find out, then we'll put up after 6 weeks. Shall we say that to enable the council to know under which provision the application for substituted service is made?
I apologize, my lord. Please don't say
Come
that.
after, come, open the CPC, find out and then put up after 2 weeks. 2 weeks. Yes,
Okay, my lord.
Lords, I am for the petitioner, my lords. To take steps for the legal heirs of the respondent number 1. They are already on record, my lords, 1.1 and 1.2. My lords, they were served, but they were not served. It was written as insufficient address, my lords. One of the legal heir is already on record, my lords. She is
If they are already in record, they must be represented by somebody.
Lords, may I assist, my lords?
They are-
We have for respondent number
That is
2.
what we are appearing, number 1.2 and 1.1.
We have instruction to file over for,
Yes,
but
my
not R3, my lords. Only legal heirs of.
We are only concerned with 1.1 and 1.2.
Yes, my lords. We will.
Government Council, Mr.
Ankit Sahu. Ankit Sahu.
Ankit
Sahu.
Sahu appears to state that he will be filing Wakalatnama on behalf of unsolved respondent number 1.1 and 1.2.
Much obliged.
Post of Wakalatnama, necessary Wakalatnama will be filed within
2 weeks.
2 weeks. Full stop. No further orders are required.
Much obliged.
Yes. Then
Your Lordship, I appear for petitioner.
Respondent number 1 is the insurance company. Though the address I have shown is from the High Court order, repeatedly it is showing that insufficient address is given. I may be permitted to serve through the panel counsel, Your Lordship. Panel counsel of United India Insurance Company Limited. They will file wakalat and that will be, R2 is already served. It will be sufficient service served.
Learned Counsel, Mr. Sohan Joseph, appearing to video conference, requested the court that it may be warranted to serve. Respondent number 1, United India Insurance Company Limited. 3. The panel advocate who usually appears before this court, in behalf of the sale insurance company. Our service through pending counsel is permitted. For this purpose, the registry takes a press notice to the respondent returnable on gives some data for
Obliged. Obliged.
171. Only one is it?
163 and 160.
168. 160 because the service is complete. In that case,
160316 PP. Yes, sir. 1603.
Order is kept.
Can I check in it?
Yeah, this is the
It's mine.
service
Service complete.
complete.
But no Pakistan.
TP what is there?
Right down, put out of the photos. Yes, sir. None appears even in the second form. Put out of the photos.
Video looking for that one.
1611.
There is one.
Same one.
Very good time. Now you are taking.
In person matter. 160.
Partly in person. None appears even in the, none appeared even in the second course. Put up after 6 days. 177. Same order. None appeared even in the second course. Put up after 6 days.
With your lordship's permission, 1615, your lordship, I have instructions to file my wakalatnama on behalf of the respondent husband in a transfer petition.
1615.
Within a week, your lordship shall
File it. It is order to place with regular length.
Bless.
File in the
Please, sir. Bless.